on criminal justice and public safety. The purpose of the hearing is to invite testimony from members of the public regarding proposed legislation that is pending before this committee. The committee will hear testimony from persons present who wish to speak for, against, or neither for nor against the bills we hear today. With leave of the chair, committee members may ask questions of any person testifying today. Other questions are not permitted. Whether or not you testify, you may submit written testimony to the committee. Please be mindful that testimony is public and is available to all once it is presented. Persons testifying at the public hearing today are advised that the hearing is live streamed and may be seen and heard by persons watching online, and that a recording of the meeting will be archived. Members of the committee, before I ask you to introduce yourselves, I have several items to address relating to the format of this meeting. First, if you're in the room here with us, please mute the audio and microphone on your electronic devices, including members sitting here at the Horseshoe. This will prevent audio disruptions both in the room and online. Second, for those joining using Zoom, if the name you used to sign into Zoom is not the same as the name you used on the legislature's website to register to testify, it may be difficult for us to identify you when it is your turn to testify. We will not close the hearing until we've given everyone on Zoom an opportunity to testify. If you have any technical difficulties, please call our committee clerk. Finally, all questions from committee members must be made with leave of the chair. Could I ask committee members to introduce themselves? Would you like to start, please?
Good afternoon. Thank you, Madam Chair. Good afternoon, everybody. Happy New Year. Matthew McIntyre, House District 18, representing 16 towns spread across portions of Penobscot, Hancock, and Washington County.
Good afternoon, Representative Chad Perkins, represent District 31, which is 7 towns in southeast Piscataquis County.
My name is Grayson Lookner. I represent House District 113, which is part of Portland.
Good afternoon. I'm Scott Searway, represent Senate District 16, which covers Waterville, Albion, Winslow, Oakland, and Fairfield.
Good afternoon. I'm Representative Bob Nutting. I represent the towns of Oakland, Smithfield, Mercer, Starks, and a portion of Sydney.
Good afternoon. I'm Representative Michael LaJoy, and I represent District 96, which is part of Worcester.
Hi, everybody. Nina Milliken, House District 16, Blue Hill, Brooksville, Castine, Sedgwick, Surrey, and Trin.
Thank you. The first bill we're going to deal with is LD 1646. And Senator? Did it come?
Yes, the amendments.
Yes.
Yeah. Do you need a copy as well, Senator Talbot Ross? Do you have a physical copy? I got here.
Oh. Okay.
Thank you.
Of course. I have no idea. What? Good.
You too. That's okay.
We're going to take testimony in the following order. Those who speak in favor of the bill, those who are speaking in opposition, and those who are speaking neither for nor against, but who wish to offer additional information to the committee. And now to present the bill.
Thank you. Good afternoon, everyone. And I'll say a warm and happy new year to each of you. It's good to be back. Senator B.B. Center, Representative Hassenfuss, and distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety. I'm Senator Rachel Talbot Ross. I represent Senate District 28, which includes part of Portland, part of the Casco Bay Islands, and in University of Southern Maine campus. I'm here today to present LD 1646. It's an act to amend Maine's Good Samaritan laws regarding suspected drug-related overdoses. I really want to begin by first recognizing the important work that this committee and indeed the Maine State Legislature as a whole has undertaken to reduce fatal overdoses in our state. That cannot be understated. I'm very, very proud of the work that we have all done. In 2022, at the height of the overdose crisis, Maine lost 723 people to accidental overdose. In response, the legislature took decisive action. We invested in treatment, we expanded access to naloxone, and we undertook what now is a three-part expansion of Maine's Good Samaritan law. As a result, we lost 490 people in 2024. And then from January to October of 2025, we lost 320 souls. Losing even one life, I know you feel this as much as I do, is a tragedy because every overdose is preventable. Beginning with the 129th legislature, we enacted Maine's first Good Samaritan law, offering limited legal protections to both the caller and the person experiencing an overdose in an effort to increase the number of people who call for help when someone is overdosing and saving lives. We learned fairly quickly that the law needed amending, however, that people on the scene continued to be arrested when law enforcement responded to overdose calls, which was not the intention of the law. As a result, the overwhelming impact unfortunately remained the same. People in these situations were not calling 911 because they feared what would happen. This was phase one of Maine's Good Samaritan law. Phase two came when the Honorable Senator Chloe Maxman partnered with Maine's recovery community to propose the expansion of the Good Samaritan law during the 130th legislature. During that time, we were losing 2 Mainers on average every day from fatal drug overdoses. We achieved a historic bipartisan victory by passing LD 1862, the strongest Good Samaritan law in this nation. This landmark legislation was built upon a shared belief that the number one priority at a scene of an overdose is to save a life, not to charge people with crimes. We stood together, Democrats, Republicans, and independents alike, to affirm Maine's commitment to valuing human life over punitive measures. That version of the Good Samaritan law ensured that individuals experiencing an overdose, as well as those assisting them, are protected from prosecution for most nonviolent crimes when they seek medical assistance. These protections do not extend to crimes against children, sex crimes, or violent crimes, as you all well know. Phase 3, which was enacted during the 131st legislature, focused on the implementation of the expanded law. People in recovery, substance use providers, and professionals across the state worked together on developing training materials and getting information out about the new protections to people who use drugs. Defense attorneys began filing motions to determine immunity when they believed their clients were eligible for protections. Law enforcement began prioritizing saving lives over charging crimes. These were bills that sought to roll back protections, and there were also, during the 131st, bills that sought to roll back protections and others that brought forward real concerns about the law. The legislature at that time, in the 131st, added operating under the influence to the list of crimes that were not protected. Then, in January of 2025, the Maine Supreme Court decided State versus Bellow, a case that raised an important question about how the Good Samaritan law is triggered. In that case, the court correctly rejected the idea that callers must use specific, as they said, magic words to receive protection. The court further noted that the requiring precise wording would produce absurd results by preventing people from receiving immunity based on technicalities and by fostering hesitation to call for help. At that same time, the court ruled that a call describing a general medical event was not enough to trigger Good Samaritan protections. That ruling has created significant uncertainty about what triggers the law and how, and has undermined the purpose of the spirit of the law. So LD 1646 directly addresses this problem by restoring clarity and strengthening the legislative intent. So let's look at the bill. As you all have just received the sponsor's amendment, my apologies that you're getting it now. We have had it prepared for quite some time, and there was a little bit of miscommunication, so my apologies. But if we look at the amendment, and I can walk you through both the original version and the amendment, so you can see where we're making changes. I will start with, if you look at the original bill, I'm just going to highlight where these two intersect, and then I'll finish with my testimony. From the original bill, you'll see section 1 is still intact, and that is to look at the terminology that the courts interpreted around a medical emergency. So we take out the words of medical emergency in that section 1 of the original bill. And then we do one other thing in section 1. We add for a person exhibiting symptoms of a drug-related overdose. So section 1 takes out the terminology medical emergency, and we add to the call for assistance for suspected drug-related overdose, or a call for assistance for a person exhibiting symptoms of a drug-related overdose. That's what section 1 does. That's still intact. We then move on to section 2, and section 2, you'll see this is where the two intersect in the amendment. And section 2, where we're talking about the symptom of a drug-related overdose and what it means, in that definition period, what we're doing in the amendment is we're tightening up the language. The language in the original version of the bill was just way too descriptive. And so we recognize this, and so we're striking and replacing it with the section in the amendment that, again, it tightens up that description from the original bill. Section 3 remains the same. This section 3, immunity from prosecution, is current law. So that stays the same. This is current law. We do take out the word medical, again, consistent with what we're trying to do in the amendment and through this bill. We take out the word medical, but section 3 of Title 17A, subsection 1111B is the same. We then move on to section 4 of the original bill. I hope this is helpful. We move on to section 4. This is also current law. And again, you'll see in the bill proposal that we just take out the words medical, and I can explain why. If you then look over at the amendment, so we've got section 1, 2, 3, 4. We are adding section 5. Section 5 is within the statute of law on the Maine Criminal Justice Academy. This section, Title 5, refers to in-service law enforcement training. So we are adding a new section in this amendment, section 5, and we're talking about the role of the board of the Maine Criminal Justice Academy. We're looking at adding training to this bill. And the training, I'll go into detail about it, but that section 5 is about training. We then look at section 6 in the amendment, and that's pretty much a grammatical, technical, so that the sections flow. So the section 6 is just unless otherwise provided. All of this work, I have to be clear, all of this work is A, about saving lives, B, about strong protections and public safety, and 3, building trusting relationships between our law enforcement, medical personnel, and the public. That's what we're talking about today. Saving lives, strong public safety, respect for public safety, strong protections, and building trusting relationships between the public, law enforcement, and medical personnel. So that's where the two bills, the original bill and the amendment, intersect. And I wanted to be real clear about it because I will reference it. So first, again, as the bill as proposed in the amendment amends our Good Samaritan law to ensure that immunity applies when assistance is requested for a suspected drug-related overdose or for a person exhibiting symptoms of a drug-related overdose. I pointed out where that is, section 1. The bill strikes language that has been interpreted too narrowly and replaces it with a clear, practical standards grounded in real-world emergencies. The bill defines symptom of drug-related overdose in section 2 to mean any physical, cognitive, or behavioral condition that may reasonably indicate a potentially life-threatening reaction to drug use. The definition explicitly includes altered mental status, impaired or irregular breathing, abnormal skin appearance, changes in consciousness, involuntary bodily functions, and other symptoms reasonably associated with drug ingestion, use, or exposure. Section 2, that's section 2. This language is reasonably tailored to the symptoms of an overdose. Many overdoses do not present in a single uniform way. The law should protect people who describe what they see and not penalize them for failing to label it correctly in that tragic, crisis-driven moment. Second, LD 1646 recognizes that clarity in the law must be paired with clarity in practice. The bill therefore includes a new requirement for training Maine's law enforcement officers on the Good Samaritan law. So beginning in January 1st, 2028, the bill requires in-service recertification training for law enforcement officers to include at least 2 hours of instruction on responding to calls for suspected drug-related overdoses or calls involving symptoms of an overdose. This training must cover how to identify overdose symptoms and must clearly explain a protected person's immunity from arrest under the Good Samaritan law. So this section here, the training, it should have been included in all of the phases that we were talking about. It mistakenly, erroneously got left out. But we know that really any law needs to have good training and understanding both by the public and those who enforce it. So the training component is in the, not in what we know as the basic law enforcement training. It's not contained in that mandatory basic law enforcement training. We are placing this in the mandatory in-service training. And as you all know, the in-service training has two pathways. One is more like an elective, and the other is mandatory. Things that fall within the mandatory in-service training are like sexual assault, domestic violence, elder abuse, human trafficking. And so this fits very well within that context of mandatory in-service training. And you'll see in the amendment that we say that this in-service training is required at no additional, within existing resources. That's the language, within existing resources. Importantly, the bill also requires that this training be provided by an organization specializing in substance use disorders and be delivered within existing resources. The mandatory in-service training that I'm talking about, that is the pathway. Subject matter experts volunteer and they come in and they do the training. This will do the same. The bill also directs the relevant board, Maine Criminal Justice Academy, to coordinate and approve this training, encourages the use of telecommunications technology, which is consistent with all the other in-service training, to increase access and ensures consistency across agencies. This approach benefits everyone. It provides officers with clear guidance, supports first responders in focusing on care, and it reinforces the public trust that the law will be applied as intended. We know that confusion about the Good Samaritan law is not theoretical. It is happening now. People have been arrested after callers reported someone unconscious or passed out. Others have been denied immunity because a caller described symptoms without performing CPR or administering naloxone, even when naloxone would not have been effective. In some cases, people have died before the courts ever resolved whether Good Samaritan protections should have applied. This kind of after-the-fact parsing of what a caller meant does not serve public safety. It discourages people from calling 911. It undermines the confidence in the law, and it contradicts the legislature's clear intent. As overdose deaths have begun to decline, it is critical that we do not weaken or erode the protections that help to make that progress possible. LD 1646 supports Maine's Good Samaritan law by restoring clarity, by reaffirming the legislator's intent, and ensuring that both the public and law enforcement share a common understanding of how the law works and how to save lives. For these reasons, and I thank you for the indulgence, I urge the committee to support LD 1646. I thank you for your time and your consideration this afternoon.
Are there any questions? Yes.
Thank you, Madam Chair. Thank you, Senator, for reading. So I'm having a lot of issues with the alternate mental status thing. What are some of the alternate mental statuses that you envision that this bill would cover? I mean, would euphoria be one of them?
It may, confusion, disorientation, unresponsiveness, agitation, paranoia.
But euphoria is an alternate mental status. Would you agree with that?
I am not going to take a position on that. I do not know.
Okay, so euphoria is an alternate mental status, and yet people take drugs specifically to get euphoria. But that doesn't mean they're overdosing. What about hallucinations? Would having hallucinations be considered an alternate mental status?
So to ask these questions, in all due respect, around what I believe is a definition of hallucination or euphoria, without the context of the scene of an overdose, people having additional symptoms of an overdose, suspected drug overdose, feels to me out of context.
It's not outcome. So you bring it before the bill.
Point of order.
And I'm trying to clarify what I'm trying to ask, Mr. Chairman.
I understand that, but our committee rules also say that questioning will not be argumentative towards.
I'm not trying to be argumentative.
Okay.
If I came across as such, I'll apologize to both the committee and to the senator.
So I think if you have clarifying questions regarding what an altered state of mind would be, you may ask that of the
I'll try to rephrase it.
testifier. But understand that they are not a medical expert, so their capacity.
I
may
understand
be-
that. Thank you, Mr. Chairman. So I'll try to be a little more succinct, and if I sounded argumentative, Senator, I apologize. But the bill you have before us has alternate mental status. And you stated several times that it was you're trying to restore the legislative intent. And I'm trying to understand how it is the legislatives and I was trying to get to this in my line of questioning, how you feel it's the original legislative intent of the bill to have protections for people who are achieving a state that specifically you would take a drug for and having that given immunity. Is that clear?
This is, and thank you for your apology. I must say that I did feel a little bit under attack there. I'm not a medical personnel. I've never had any medical training. And so it's difficult to answer your question solely based on that one condition. This bill is about a number of conditions that present themselves. So as I've said before, it's a person exhibiting symptoms of drug-related overdose. It's not just a euphoric situation. And all of these things come together in which people are calling for assistance. And so you have to understand, it's not just folks taking drugs. There's something that's happening on that scene that brings a person to call 911 for assistance because they suspect a drug overdose or a person exhibiting drug-related overdose. So that's really critical. It's critical because what we're talking about, the context of this is someone's calling 911 and asking for help. That's the context of the bill.
Right. Okay. So just to clarify, you said that they're calling 911 because of a drug overdose, but
Suspected. If you look at section 1, there's the language there. Out of all due respect, Representative, suspected drug-related overdose in the amendment or a call for assistance for a person exhibiting symptoms of a drug-related overdose, not of euphoric high, in my opinion.
right. But the reason I'm asking is because I'm wondering if you think that the language alternate mental status is too broad, considering what could be consistent with a alternate mental status. That's what I'm trying to ask. I'm asking
Excuse
you to
me,
clarify that.
In all due
Representative
respect, I'm not sure if that's a question or you're making a comment.
No, I'm asking if you
Excuse me.
feel that's too broad.
Representative Perkins. Representative Milliken?
Thank you, Madam Chair. Do you think that people are calling 911 to report euphoria? I think you already kind of got at that.
I do not.
Thank you. And do you also think that perhaps the intention of the bill, or is my understanding correct, that your intention of the bill is to be broad so that we give people immunity when they are calling to save somebody's life?
I would agree with that. Again, the principal intent here is to save lives by encouraging people to call for medical assistance at the scene of what they believe could be an overdose.
And considering the limitations that have been placed both on this recent court case and on some of the past assaults or attempts to roll back the provisions of the Good Samaritan law, do you think it is a good idea to be a little bit broad?
I believe in this amendment and then this bill as a response to, current day situations. And I believe that the spirit of this law that this committee and the legislature passed is still one that we are trying to achieve. And that this bill takes one more step in making sure that both the public and law enforcement and medical personnel clearly understand how to implement this law.
Senator, thank you very much for this bill. It's a very important bill.
Are there other questions? Yes.
Thank you, Madam
Representative
Chair.
Nutting.
Thank you, Senator, for your bill. The confusion that you allege in the system, or it sounds like there's confusion in the system, in your opinion, is your bill to eliminate the confusion at the patient level, or at the law enforcement level, or at the legal or court level? Where will your bill settle the confusion in your mind?
Thank you for the question, Representative. I believe at all of those levels, because if one of those levels is not in sync with the other, the law doesn't work at all. And so at each of those levels that you just spoke about, if they're not in sync, if there isn't an understanding clearly about the Good Samaritan law and how it works, then it just doesn't. So it will impact all of those levels. And I would just add that, again, what we erroneously did not do, in the past is to include training for law enforcement officers. Law enforcement officers deserve training on this extraordinarily, significant law. And it does not appear, have been some situations in which it is been debatable on whether or not the people on the scene understand, law enforcement understands as well what is taking place. This is a complicated matter, and it makes sense that we're back here. It makes sense that as we implement and pass laws and we see what the result is, that we use that result and we come back and we improve it and then we strengthen it. It is in many ways, it's a continually improving model that we are trying to get right in order to save lives.
Thank you.
Representative McIntyre.
Thank you, Madam Chair. Thank you, Senator. I'd like to bounce around some of the things that you wrote in your testimony to guide towards my question. I agree, losing even one life is a tragedy. That's from page 1. I think it's page 3, where you indicate that there is confusion in application of the Good Samaritan law. That's not theoretical. It is happening now. Do you have any specific examples of where that confusion has been identified in part 2, if I may? What are the numbers? How many instances have been brought to our attention where that confusion is identified? And just try to paint to me a picture of the significance of the confusion that you're sharing, that you're stating exists.
I thank you for the question. There are a number of people who are going to be testifying today in support of this bill that have real life experiences that can detail that confusion. We also have legal personnel here who will be able to give specific examples of how that confusion has played out. Generally speaking, the confusion has arisen, generally speaking, and this is not to fault any particular decision-making in the system at all. This is just to bring about that there are some gray areas that this bill helps to clarify. And that is in crisis, when someone believes that an overdose is happening or they see symptoms of an overdose happening, in calling 911, which is a trust factor, I'm calling 911, there has been a confusion around the language someone uses in the moment of that crisis to describe what's going on. And when law enforcement does come to clear a scene, shows up on the scene, 911, not using specific terminology to describe a scene has resulted in arrests being made on during that call, in which the people who have made the call believe that they are doing so within the spirit of the Good Samaritan. So the confusion comes in, they're calling 911 and law enforcement arrives at the scene. And because of either the language that they used in that 911 call, it has not resulted in what the spirit of this law aims to achieve. But you will get more specific examples of this as testimony comes forth this afternoon.
Yes, Senator Searway.
Thank you, Madam Chair. Thank you, Madam Chair. I was looking this over, and I'm hoping that we hear from any law enforcement officers that experienced the confusion that you're talking about. I know you're hearing from one side, but not the other.
Is that a question, Senator?
No, but I'm just hoping. But the other part of this, it seems like it's
Do
undermining.
you have a question?
Yeah, I'm
Senator
getting to
Searway?
that. I have to explain it. I'm sorry, but undermining existing law that allows this will be allowing drug distributors to not be held accountable when a sale results in a serious injury or death. So they have to still do their job. And they are taking away medical, which I just don't understand why you would take the medical out if most overdose calls, a medical ambulance or somebody's going to respond, and they're going to be waiting at the scene. And then when everything's safe, they come in.
Senator Searway, do you have a question?
Point of order. My point is I'm trying to explain what the question is going to be, but I have to tell why I'm asking this question. Is that okay? I've gone through this many times, and I'm trying to explain the question. Explain what I'm trying to question. And my big question was about the medical part, why it's being taken out when we have medical ambulances showing up. The law enforcement officers are not trained to be medical professionals.
So perhaps you want to ask why medical is being
Right,
taken out.
exactly. And
So
that's what
that
I'm
would be
trying
the
to get
question.
to.
That
So,
would be the
thank you,
question.
Madam Chair.
Okay.
If I understand your question correctly, Senator, you are interpreting taking medical out as in medical personnel would not show up on a scene, and that's not what this bill does. When you call 911, we're not changing that particular first responder activity. We are so medical personnel would still show up. 911, you call, law enforcement is dispatched, they go in to clear a scene, and medical personnel come in when it's safe. That is routine. That this bill is not changing that in any way. What we are changing, if I can answer the question, is relating back to the court case of State versus Bellow. And that is whether or not a caller must explicitly state that an overdose is occurring to receive immunity under the Good Samaritan law, or if reporting a general medical event is enough to trigger the protection. So we're taking the word medical out because the Supreme Court did acknowledge that requiring callers to explicitly state that an overdose is happening could lead to tragic consequences and a hesitation to call for help to save a life. So by removing that one term within that section of law, it's section 1, 17A, within that section of law, we are acknowledging that you don't have to have the magic words to describe an overdose, but it is an emergency that prompts you to call 911 to help save that life. So I just want to make sure you understand that we're not removing medical personnel from any of this at all.
It's very confusing, and
Yeah.
to me, it's gonna
Yeah.
be very difficult just for law enforcement officers to understand whether they're making a mistake or not.
Point of order,
And I'm
Senator.
just asking how that works if you take medical out.
Respectfully, Senator, I do not believe that this bill is 1646 takes medical out, to quote you. We are not taking medical out. The whole point of the bill is for medical to show up. I mean, that we want a life saved. And so I can't stress to you enough that this is not about revising the way in which first responders show up at scenes. This isn't about revising any way that law enforcement or 911 dispatch happens, because we want medical to show up to save a life. And so I can assure you that this bill does not change that in any way at all.
Representative Ardell.
Thank you, Madam Chair. And hello, Senator
Hi.
Ross. I'm a fan of simplicity, really. Pragmatic responses to issues is kind of one of my hallmarks,
We share that.
which I enjoy. To satisfy State versus Bellow, which states that the caller must state that an overdose is occurring. Wouldn't a simpler solution be to train dispatch, 911 dispatch, to ask the caller, do you think an overdose is occurring?
That's a great question, and I would respond by saying that is something that could actually be added to the bill if you'd like. But to require people who are in crisis, that are responding to a potential tragedy of a life being lost, to ask them questions to clarify what's going on is a matter of seconds that could save that life. You know, you've been in law enforcement, or may still be in law enforcement, but those seconds really matter. And so there is a possibility that something like that could happen, but it would not be a substitute for what this bill is trying to achieve. And that is because in the moment of crisis, during the scene of what one might suspect as an overdose, you want to be fast, you want to be quick, you're calling 911, you're asking for help, and the help needs to happen fairly. So you and I can debate that, but I do believe that this amendment fully satisfies that piece of it, and I don't mind adding that as an additional tool, but I do think that makes the burden on the person who is calling 911. I'm asking for help. So we can continue to debate it, and I'll continue
Sure.
to think about it.
And this
Thank
may
you
be,
for bringing it up.
this may be something for the work session, but I think it's important for everyone to remember that 911 dispatchers routinely ask clarifying questions as part of the call. And I think the clarifying question of something as simple as, do you think an overdose is occurring, could basically replace this entire bill with a very simple and pragmatic solution. So,
And
thank you.
we'd mandate that.
Sure,
Okay.
why not?
It wouldn't be able to, in all due respect, if I can respond.
Okay.
It wouldn't replace the whole entire bill because we are also talking about mandatory in-service training, and I don't want to lose that piece of the bill. But we can continue to talk about.
I think it would be a great opportunity to train dispatch as to what question they would need to ask.
I
So,
agree.
Thank you.
Representative Hassenfuss.
No, I was just going to remind everybody that, the work session is the appropriate place to have the robust conversations, to express opinions, to gather further information from our analysts or from experts. And to remind everybody that the public hearing is really the time to allow the public to express their opinions of the bill, to ask them clarifying questions to help us to clarify their testimony. If it's questions relating to the mechanics of the bill, that's a more appropriate question for our analyst who is trained in drafting and editing these bills. And so let's just try to remember, the purpose of public hearings versus the purpose of work sessions and which individual is appropriate for what questions to be asked. And with that, I do have a question, which I believe it's a question more to come back on work session. But it's more of a general question, and that is how important is the subjective intent of the caller? And should the purpose of the Good Samaritan bill be the subjective intent of the caller, or should it be the objective happenings on the ground? And so I think that is something that can be saved for work session.
Okay. Representative Milliken?
Thank you, Madam Chair. I think the nature of what I was going to say was would more align with the work session, so I'll hold.
Okay. Okay.
If I may, Senator, I just want to leave the committee with one further thought, and that is when you look at the statute, Title 17A, the main criminal code, and you look at Chapter 45 under drugs, subsection 1111-A, and it looks at this is Good Samaritan, it looks at the immunity. If you go into the section that talks about the definition, so 1B, I just want to remind you what the spirit of this law looks like. 1B gives the definition of protected person, and it means a person who, in good faith, calls for assistance for another person experiencing a suspected drug-related overdose, any person rendering aid at the location of the suspected drug-related overdose, and any person who is experiencing a suspected drug-related overdose. This is current law. This is current law. And you can look it up yourself. But I bring your attention to it because it says a protected person means a person who in good faith. So if you were trying to really capture what the spirit of this law is, it's a person who in good faith. We don't define what good faith is. Right? We don't define it, but we trust that a person in good faith who's calling for assistance. And so I just need you to wrap your heads around, and maybe your hearts around, this spirit of this law. And I believe that 1646 as amended actually realizes the spirit of the law and reduces the confusion for all of the people, all of the folks who are impacted, law enforcement, medical personnel, the public, and certainly our family and friends who are experiencing these tragic situations. Thank you.
Thank you. Are there other questions? Thank you very much.
Thank you.
Is there anybody else that would like to speak in favor of this? Please.
Had to bring my trusty friend with me, so. A little bit of insurance, if you will. Bernice, while I'm signing this, would you? I'm going to take one of these, Representative. Good afternoon. Senator B.B. Center, Representative Hassenfuss, and my esteemed colleagues of the Criminal Justice and Public Safety Committee. I am Representative Michael Joy, and I represent House District 96, which includes a portion of Lewiston. I am here today as a proud co-sponsor of LD 1646. sponsored by Senator Talbot Ross. This bill is about one thing and one thing only: saving lives. During the 130th legislature, Democrats, Republicans, advocates, first responders, and people with life experience came together to strengthen Maine's Good Samaritan law amid an overdose crisis. The purpose of the Good Samaritan law has always been clear: to ensure people call for help without fear. It was never meant to be a legal puzzle or a test of whether somebody uses the right words in the moment of panic. I speak to you not only as a legislator, but as someone who spent 31 years with the City of Lewiston Fire Department, including time as fire chief. From my personal experience, I can tell you that during emergencies, people do not speak in legal language. They speak in fear, they speak in urgency, and they speak to save someone they love. When someone calls 911 because a person may be experiencing an overdose, the focus must be on immediate care. The public needs to know that no magic words are required to receive immunity protections. LD 1646 restores the original intent of the Good Samaritan law by making clear that protections apply when someone calls for help. For a person showing signs of a drug-related overdose, regardless of whether or not the caller uses the word overdose. This clarity allows everyone on scene to focus on saving a life, not navigating legal uncertainty. The urgency is real, even in my own community. According to the Maine Drug Data Report published on October 2025, 26 Lewiston residents were among the suspected and confirmed fatal statewide in 2024. From January through October 25, that number has already reached 27. Every fatal dose is a family forever change and a loss to the community. Every life is worth saving. LD 1646 reaffirms Maine's commitment to compassion, clarity, and common sense. I urge you to support this bill. Our neighbors' lives are at stake. I thank you for your time and consideration. While I was putting this together, or reading through it, I should say, it came to mind of a couple of instances. One of them is a young man that my children grew up with, and a male subject, and extraordinarily good sports person, especially in hockey. Very, very good with children, especially coaching and stuff like that. The individual was married, had children, had a decent life. And for whatever reason, whether it was life stress or other factors, I'm not sure. I don't know what the terminology would be, but he fell. In other words, he started drinking and doing drugs. Throughout that area, a divorce came around, of course, and he lost many other things. The fact of the matter is he always went back for help. The last time I saw him, my wife and I volunteer at the Franco Center in Lewiston, and right behind us, one of the buildings that was part of the structural area that was separated turned into a rehab center where individuals go there, they live there, and they take part in different activities and so on. One day, my wife and I were outside and we happened to meet this young man, which we hadn't seen in a while, which we knew he had problems and stuff. He was extremely happy to see us, very, very excited in the sense as to where he was at within his treatment, and also the fact that the people that ran the establishment had asked him if he would become, I don't know if you call it a sub-instructor or a helper or what have you. And he thought that was the greatest thing in the world because he could do something for somebody else. I don't know if, I think it was about 3 or 4 weeks later, I found out that he died of an overdose. I'm not sure what transpired, but I do know in talking to some of these individuals, especially the individuals that do the educational process, is that many times they will be asked to go out to different houses as where overdoses happen. And number one, talk to the people and try to stop them, and move along in that direction to see what they can do. I don't know if that was part of why he went to where he went, but the fact of the matter is he died of an overdose. Nobody called it in. The next morning, after the individuals in the other building called PD to let him know that he had not shown up, they internally did an investigation with the personnel there to find out where he might have gone. And anyways, they found out and they found him. And he was alone. And of course, deceased. That really, it really bothered me because in my opinion, he was a young man that was going to try to do something right. As many times as he fell, he was still at it. And the ending, of course, was tragic. It was tragic for the family, it was tragic for the friends, and so on. I just thought I'd mention that because of its importance. Also, I do realize by talking positive about the action or the bill moving forward brings questions to many of, I shouldn't say many, a number of individuals around the horseshoe, as well as behind me, especially behind me, where I may have worked with some of them responding to calls. I have a different view as a firefighter and or responding individual that the police have. They're trained to look at certain items and visualize as they're either giving care to an individual or trying to calm the individual down. And yes, the ambulance comes in, rescue comes in, and then takes over with the patient. I signed on to this because I think it's important. Also, in my background, I am known to try to move things forward until there's such a time that there is no possible way that you can come to a conclusion. I think in this factor, we can come to a conclusion. And I think it can be positive, but it's going to take debate, negative and positive. But I think we can get there. Thank you. I appreciate your time.
Thank you. Are there questions? Representative Nutting?
Thank you, Madam Chair. Thank you, Representative LaJoy, for your testimony. I'm still struggling to find out where this bill is going to fix confusion. So as a first responder yourself, am I correct in assuming that there is no confusion with the paramedic or the EMT when they arrive on the scene? They don't care what the law says. They're just there to save that person's life. Is that fair?
I would say to you, yes, because my goal is to provide help to that particular individual. However, also, the fact is, if first aid can be given to the individual prior to first responders like myself, getting to the building, that is an advantageous point that can be given to that individual.
Yeah.
And I do know that a lot of police departments in today's world do training on different types of calls and first response. So that would not be something new for them. Again, I will tell you this, as a first responder, when I go into a building or a situation, and let's say there's a patient on the floor, yes, I will go to the patient, but as I go to that patient, my eyes are roaming all over the place. And I try to take pictures in my mind because I have to make a report after. And just about everything is important before I get to that patient, including that patient. The police do the same thing, but possibly with a different mindset. They have the laws that apply to them that they have to deal with, that I don't necessarily have to deal with, although I may be called in court to testify on those conditions. I hope that.
No, that's a fine answer. And my last question is, from your experience, do you believe that when a law enforcement officer arrives on the scene of an overdose or a medical emergency or whatever you want to call it, that their first duty is to try to save the person that's on the ground and that the rest of it comes later?
I can't put myself in their positions. But I would tell you that if I was an officer, my first goal would be to attend to the patient. That's the best
Thank you,
answer I can give you.
Representative LaJoy.
Are there any other questions for Representative? Yes, Senator Searway.
Thank you, Madam Chair. So a first responder gets there, you know there's a medical issue. Why would we take out medical in this? Because usually, and you know, I mean, when it comes over dispatch as an overdose, not only is police gonna be called, but rescue's gonna be called. So why would you expect the law enforcement officer to know all this medical stuff in the statute? And have 2 hours of training in medical? I just don't understand. How do you think that that's gonna help? I mean, I think.
Yeah.
Maybe the dispatcher clarifying might be the answer.
I think I have an answer for you.
Yeah.
So the first responder, whether it's police, fire, or EMS, once inside the building and or at the emergency, will attend to the individual that needs that help first. As I told you before, as you go to that person, you train, and if you do it often enough, it's automatic. You look around and you visualize different things that you can have available to you when you do a report. You don't even know you're doing it, but you're doing it. You go to the patient, you look at the patient, you probably check his carotid artery to see if he's got a pulse. If he or she does have a pulse, then you do not have the tools possibly at that time to render help. Therefore, you must wait for the medical to come in, which 9 out of 10, they're right behind you at the door, you know? So this is something that is trying to happen that I believe is good for the communities, for the state, for the families, for the individuals that have that crisis as well. And my belief is, and in forwarding with this, and in sponsoring this bill, is I am looking for dialogue. The amendment is a perfect item that just came up. I am looking for debate or discussion to come up with a conclusion, potentially. There's always that little potential behind me. I know there's individuals behind me that have many questions, answers to your questions. You're welcome.
Representative McIntyre? Did you have something you wanted to ask?
Thank you, Madam Chair. Thank you, Representative, for your testimony, and sorry for the loss, the young man that you suspected. Trying to make a correlation.
Mhm.
In the testimony by the bill sponsor, I see that we have reductions, consistent reductions from 22 to 24 in the number of overdose deaths. That's a good thing. In your testimony, you state that you lost 26 individuals to overdose in the year 2024.
Right.
In 2025, regrettably, there's an uptick of at least one
That's correct.
thus far. My question to you is, do you believe that there is a correlation in the Lewiston trends to the usage of the magic words has been appearing several times? Do you believe there is a correlation to those numbers to the proposition of this bill? A direct correlation?
I think, I don't know if I can answer that properly for you. And I believe that individuals behind me may be able to help you out with that question. May I also bring another fact is for many years, I was involved in the 911 system with Lewiston Auburn 911. As a matter of fact, it began way back in 1994 and 96. It became a reality. I was involved with that for quite a long time until not too long ago. The fact of the matter is when somebody calls in, if you're a dispatcher, you can hear a lot of bad words along with that call that comes in. So when somebody calls in, they're excited, they're worried, they're anxious. Many words can come out that many times may not identify the true cause of the individual being down. And a dispatcher in today's world, bless their soul, have to decipher that. And it's very difficult. So I think that's another leg, that has to be potentially looked at. The amendment may help us out with regards to training. I know that our LA 911 does have numerous training hours. I have the Auburn Fire Chief, Police Chief that's here today that could attest to that. It's a crazy world. I don't know what else to say, but put yourself in back of that mic and a 911 dispatcher, and they're screaming at you. They're using foul language, and they don't leave you alone. It's quite hectic.
Thank you, Representative.
Yep.
Do you have a question, Senator Searway?
Thank you, Madam Chair. What you just said about the dispatcher, same goes for the law enforcement officer that goes after what dispatcher tells you took place. They're looking for safety when they go in, and then they get all what they can do and get the medical in there as soon as they can. Did you expect the officer to do all medical analysis? And that's why I'm kind of wondering why they would take medical out.
May I ask,
Yeah.
may I answer your question this way? I would expect the officer to act as he was trained for those particular calls. That's my best answer for you.
Representative, thank you.
You're welcome.
Is there anybody else that would like to speak in favor of this legislation?
Thank you very much.
Do you have your copies?
I don't have my copies with me. I had some technical difficulties. Can I will go straight to my office after this and upload them right after this hearing, if that's all right. Through the portal.
That's great.
Thank you so much. I
you.
apologize. I had some difficulties, like everyone, I'm sure, in getting here this morning. Good morning, or I think we're in the afternoon at this point. My name is Freyla Tarpinian. I am appearing for you for the first time in a new role. I'm the executive director of the Maine Commission on Public Defense Services. It's an honor to be here again. I am testifying in support of LD 1646. I first do want to echo the thanks to this committee in particular and the legislature as a whole for all the many steps that have been taken to save lives. I do believe it's having an impact, and I'm confident that you've saved lives through your actions. I believe that this law does need a tweak, and ultimately, my understanding of your intent when you passed this was that the cases never get to the people that I work with. So I work with defense attorneys. Last time I appeared before you, I was the district defender, and I handled cases, including some cases that have filed motions that would implicate this immunity case. And but the people that I work with now, defense attorneys, have filed these motions. So we have been working with this law and trying to decipher it. My understanding is you don't want these cases to get to the court. The goal of the law is to ensure that at the scene, properly trained law enforcement are able to divert the cases away from prosecution and really focus on safety. You've made this decision to focus the attention on the scene from law enforcement and all emergency responders on the person who needs medical attention and de-emphasize the prosecution piece or the law enforcement piece, which is unusual. I want to say that that's an unusual law. There's not another one I can think of like it. You've done this in the goal of saving lives. And so the key to this law's success is that in the moment, the people who are calling are very clear with what's going to happen when they make the call, that nobody who might be involved in something that they don't want to bring to law enforcement is going to ignore somebody who is suffering and not call because of fear or fear of getting them in trouble, not call because somebody who they suspect has used substances. They don't want that person held accountable. And so they're not going to call. The goal of the law is to make sure that people call and are not afraid to call. And that's where the clarity comes in. So if this law is coming before the court and we're having motions and we're having a lot of wordsmithing discussions as lawyers, which we like to do, for better or for worse, the purpose of the law is being weakened every time we do that. Because the person who has called intending that this be the case, thinking that this was the right thing to do, is being told that, in fact, no. So the case of Billow is the clearest example. The court expected the person calling 911 to be able to distinguish the difference between a medical event and a medical emergency. I don't know that I could do that. I'm certain I could not do that if I thought someone was dying in my vicinity. And so that's the key. That's the clarity or the confusion that these changes are intended to fix, which is to take out this word, again, what lawyers do, and I'm as guilty as anyone, wordsmithing the significance of a word like medical and focusing on whether the person is correct, because you're assuming that the caller is correct in what they believe is a medical emergency and not a medical event, and that a judge months down the road are going to agree with them to make the law have effect. And it really just strips it down to what happens and what dispatchers are trained to do. Dispatchers are trained to ask for what the person sees. So if you hear 911 calls, and I have, for better or for worse, at this point in my career, listened to hundreds, if not thousands of 911 calls, people of varying degrees of presentation, from very calm and rational to very hysterical, are being asked questions to describe what they're seeing on the ground. What does the person look like? What do you hear? What are you noticing? Why did you call? Essentially, the dispatcher doesn't usually say, why did you call? But they say, describe what's looking, what does it look like? What does it sound like? What do you see around them? Describe it to me. And that's what dispatch does. That's what they always do. That's what these calls consist of, are these descriptions of what they're being seen, so that the dispatcher can make the correct decision about what to do, which is usually to dispatch. If a person is calling and suffering from what they appear to be medical distress, they're going to dispatch emergency personnel. They're also going to dispatch law enforcement to ensure the scene is safe. And so that is a standard response that happens all day, every day. And again, this law would not change anything having to do with that. The statute requires certainty to be effective. If people are wrong and they don't understand and they're confused about what's going to happen when they call, it doesn't matter if a lawyer 6 months down the road is successful or unsuccessful during a motion. It's the person on the ground, on the street, and we're not assuming that all these people know what happened. So we can't assume that the caller knows that there's an overdose. The caller has come upon a scene. Maybe they do know. Maybe they were there. Maybe they don't know. Maybe they came across a parked car. And we see all sorts of situations. We have people call related to calls like this, who are related to the person, who know the person, who have details about the context. And we have a lot of calls from strangers. Somebody wandering down the street. We had a call about somebody sleeping in a driveway, couldn't be roused. Are they heavy sleeper or did they overdose? The call was because they thought perhaps the person was not alive due to drugs. That's what the call consisted of. A girlfriend who's a medical provider calls describing somebody who's not suffering what we would think of as an opioid overdose. This person is very agitated, is sweating, is not making sense. This person had open heart surgery 2 weeks before because the substances they use are stimulants. And so it's not going to look like someone going to sleep. That's going to look like somebody who's got a lot of energy. And so in that case, that person thought that call was a call that they should make because they were very desperate. And yet months down the road, judges are just determining whether was this a medical event or a medical emergency. And then later on, so the key to this law's success is really certainty. And so simplifying the definition to what the calls consist of, which are descriptions of what the person sees, is the key to making it more successful and easier, and hopefully less coming to the attention of it coming into the system. The goal of this law is to get these cases out of the system. That's what the immunity is intended to do. So I thank you for your consideration. And I just want to speak in support of making sure that, again, lawyers are doing law jobs, but that the people who are calling know the consequences of that call, and they're hopefully making the right decision, because it is about saving lives at the end of the day.
Thank you very much.
Thank you.
Are there any questions? Yes, Representative Nutting?
Thank you, Madam Chair. Thank you for your testimony today. In my search for the confusion, I think you've helped me. The confusion, was the confusion somewhat corrected or fixed by the law court's decision in early of 2025? They said you didn't have, magic words didn't exist.
Yeah.
Didn't that help?
I don't think so, because in that decision brought in the medical event versus medical emergency paragraph, which I think is in fact more problematic in a lot of ways. What the court said is that there has to be an ongoing medical emergency. A medical event does not rise essentially to the level of implicating the immunity. And so lawyers will be sussing out months down the road if what that person called about was a medical emergency or a medical event. And this person has already called 911, which typically is an emergency situation. But these are prompted by a 911 call. These are emergency calls, are foundational requirement of this law. And so you call 911 because you believe it's an emergency. The law court's decision means that you have to be correct, and you have to distinguish on the ground in that moment whether what you're seeing is considered by a judge in 6 months a medical emergency or simply a medical event. And I'm telling you that I'm not sure what the difference between those two things are.
Okay, thank you.
Are there any other, Senator Searway, do you have a question?
Yes, thank you, Madam Chair. I think I'm more confused. When you say an overdose call, it is a medical emergency if they're overdosing. So why are you not saying this is a medical emergency? Why are you not saying that?
There has to be a medical emergency for the call to be prompted, and then the description has to describe medical symptoms. And so I don't agree with the premise that this takes us away from a medical event. This is prompted by a 911 call that is describing physical symptoms of somebody who's so unwell that you suspect that they have overdosed or who use substances at a point that their life is threatened. If you use substances and your life is not threatened, typically a 911 call is not the call that's being made.
Follow-up question?
Yeah, well, I'm confused because, I've had calls where a person was out of control, whatever, but they had dementia, that sort of thing. But still, we had to have rescue come because, things happen. And we don't know if it's medical, mental health, whatever. But it gets, the dispatch determines that, and then they send them. I just don't, from this bill, it seems to me that it's saying that we have to be medical professionals to determine these things on scene as the law enforcement officer. And that's putting a burden onto the law enforcement officer much more than it's ever been. And to me, that's where I'm getting this. Because now you're saying that if it's called in, and then we have to determine what kind of medical condition so that we can eliminate the problem with the courts. But I'm very confused. I'm confused on how this works.
I think quite the opposite. So if a police officer is dispatched to a scene and is responding to, dispatch would give the officer information via usually radio traffic about what they're going to enter into, so what they're expecting. And if the call is because of somebody who's medically unwell, and police are dispatched to that scene because often they are, a police officer is trained and is expected, if there's going to be a criminal action, to write a detailed report, but is responsible for that call and is going to come and assess a scene automatically, no matter what the call is. So in the dementia patient case, like that is unfortunately something that happens. A law enforcement officer is absolutely capable of going on scene and recognizing that somebody is suffering from a cognitive medical event not related to overdose, and the appropriate response to that scene. I know our officers are able to make decisions on the ground.
So that would not be an overdose situation.
Correct,
So
and the
this
law
was
wouldn't.
supposed to be overdose situation, right? So I'm just confused where this comes in. It seems like it's like looking for a way to stop an officer from doing any prevention for a crime. And really, that's where it seems on this. And I think that a simple solution was brought up, but anyway, but this, taking the medical out of it, it's really setting law enforcement officers up to fail. That's what I feel. And give me wrong, but it just seems like it spells it all out, all these medical lingo, whatever, of all these situations. And for us, we're emergency responders. So how's that work if you're expected to know all this stuff and make that determination, that sort of thing?
I think the law that you've passed that's currently in effect requires a police officer on the ground to understand on the scene whether you're dealing with a medical event or a medical emergency already.
Right.
That is more complicated than having an officer respond to symptoms that are related to overdose that are explicit. I think this simplifies it.
Yes.
Thank you very much.
Thank you. And I'll get that testimony uploaded.
Okay. Is there anybody else that would like to speak in favor of this bill? Is there anyone online? Oh, I'm sorry. I'm sorry. Please.
Good afternoon, Chair Senator Ann Beebe Carter and Representative Tavis Hasselfuss and members of the Committee on Criminal Justice and Public Safety. My name is Kelly Merrill and I live in Stratton, Maine. I co-chair the Maine Green Independent Party, which has 37,000 members statewide. We support LD 1646, an act to amend Maine's Good Samaritan law regarding suspected drug-related overdoses, and urge the committee to vote ought to pass in order to restore the original intent of the Good Sam law. We know how powerful Maine's Good Samaritan law is as a life-saving measure. One study attributed a 15% reduction in deaths to a combination of such laws, where there is also robust naloxone access, such as here in our state. That data is supported by the National Bureau of Economic Research. Strengthening the Good Sam law will also continue to educate law enforcement partners who are needed to ensure effective application. As everyone knows, Maine has historically been one of the hardest hit states in the country as far as the overdose epidemic is concerned, peaking mid-pandemic in 2022 with 723 deaths. But for 3 consecutive years since, overdose deaths have fallen. It's not one measure that is responsible for this, but all the measures we have supported to mitigate the loss of our family members, friends, and neighbors. I'd like to take a moment to review the numbers. From 2022 to 2023, the number of overdose deaths fell dramatically from their peak of 723 souls in 2022 to 606 in 2023. That's 117 less deaths, or just over 16%. From 2023 to 2024, the number of deaths went from 606 to 490. That's 116 less overdose deaths, an over 19% reduction. And projected numbers for 2025 demonstrate the same trend. We anticipate those numbers will be below 400. So let's just say 395, which would be 95 less overdose deaths. Again, over 19%. Harm reduction measures are working. Let us continue that trend and save lives. We urge this committee to vote ought to pass on LD 1646 to strengthen Maine's Good Sam laws. Thank you so much.
Thank you. Do we have your testimony?
I do. It's significantly revised,
Oh,
but I'm happy to send it around.
okay.
Oh, do you want me? Sure. Okay. Yes. Yeah.
Are there any questions? Are there any questions for her? Okay, thank you. Would you like to? Okay, please.
Good afternoon. Yep, still afternoon. Senator Beebe, Senator Representative Hassenfuss, members of the Criminal Justice and Public Safety Committee. My name is Alicia Melnick. I am here today on behalf of the ACLU of Maine and in support of LD 1646, an act to amend Maine's Good Samaritan laws regarding suspected drug-related overdoses. I'm here on behalf of the ACLU, a statewide organization committed to advancing and preserving civil liberties guaranteed by the Maine and U.S. constitutions. And on behalf of the ACLU, I urge you to support this bill. As you've heard, the Good Samaritan law was designed to save lives. That was the underlying purpose and the legislative intent of the law that was passed in 2019 and revised and strengthened since then. However, the recent ruling actually creates really highlights again some confusion around the application of this law in the way that it was intended. So that the person calling for assistance, if they fail to use words that clearly show the caller believed they were witnessing an overdose and not another kind of a medical emergency or event, would not be able to gain the benefits of the intent of the law. Opioid overdoses can often be reversed if a person receives emergency medical attention in time. However, people are often afraid to call emergency services for help for fear of arrest or prosecution. And the Maine legislature recognized that saving lives was more important than punishing someone for a low-level drug offense when it enacted this law originally. Again, under the recent interpretation of the law, it only applies when a caller suspects a drug-related overdose, not when they are concerned about a medical event. This restrictive interpretation and a concerned passerby's failure to use exactly the right words meant that the defendant was not protected from prosecution. The implications of this court's ruling led to this bill and the intent to clarify, as you've heard, the goals of the law so that it's implemented as intended. Witnessing a potentially deadly drug overdose can be extremely stressful, and most people are not familiar with the intricacies of every state law. It's unwise, unfair, and unsafe to expect or require people in an emergency situation to know exactly what words to use when calling for help. The greatest concern of a person in that situation should be how they can most quickly get help and save a life, not if they are using precisely the right phrasing to be protected under the law. By amending the Good Samaritan law to include calls for assistance for a person exhibiting symptoms of a drug-related overdose, this committee will continue to invest in Maine's public health response to opioid overdoses and save more lives. We urge you to vote ought to pass on this bill. And as you've heard, it really is just about acknowledging that the person calling in is best suited to not to be making kind of assessments about as a physician or a health professional would, but being able to report the actual, again, symptoms that a reasonable person would perceive as being related to a drug overdose. So thank you for your time today, and I'm happy to answer any questions.
Are there any questions? Seeing none, thank you very much.
Thank you.
Is there anybody else that would like to speak in favor of this legislation? Yes? Okay. Thank you.
Guess I have to sign in here. Senator Beebe, Senator Representative Hassan Fuss, members of the Criminal Justice and Public Safety Committee. My name is Lonnie Graham. I'm a physician and former Chief Public Health Officer for the state of Maine. I am submitting testimony in support of LD 1646 on behalf of the Maine Medical Association and the Maine Osteopathic Association. We have all determined that testifying in support of LD 1646 is important because its passage is vital in Maine's continuing effort to reduce the terrible death toll drug addiction takes each and every year. We believe it is critical to the work on this issue, which includes the 1,000 Lives campaign, the Maine Medical Association, whose goal is to reduce opioid-related deaths in Maine by 1,000 from current predictions over a 5-year span. An overdose is a medical emergency in which seconds matter. Early signs of life-threatening overdose, confusion, extreme sedation, abnormal or slowed breathing, cyanosis, or inability to waken are often frightening and ambiguous to bystanders. In these moments, people describe what they see. They do not make a diagnosis or speak in legal terms. Expecting precise language during a crisis is neither medically sound nor realistic. Unfortunately, overdose emergencies are not rare or isolated events in Maine. In 2024 alone, there were 8,535 overdoses reported statewide, and 2,069 required EMS response. Many Mainers, friends, neighbors, or family members each and every year must decide in real time whether to call for help. When legal protection hinges on the use of specific words, confusion and hesitation are inevitable, and delay can be fatal. Brain injury from hypoxia can begin within minutes. Death can follow shortly thereafter. Maine's Good Samaritan law was enacted to address this exact problem by reducing fear of arrest and encouraging timely calls to 911. Evidence shows that this approach works. A 2020 study by the Government Accounting Office found a nationwide pattern of lower opioid-related deaths among states that enacted Good Samaritan laws, both compared to death rates prior to the law's enactment and death rates in states without such laws. We celebrated that success. In January 25, the court decision introduced uncertainty by suggesting that a call for a general medical event might not qualify for the Good Samaritan protection. From a medical perspective, this ambiguity is dangerous People in crisis should not have to pause to choose legally precise language when someone is struggling to breathe. LD 1646 resolves this problem by aligning the law with medical reality. It clarifies Good Samaritan protections apply when someone seeks help for a person showing signs or symptoms of drug-related overdose, even if the caller does not explicitly say overdose. Clear standards benefit everyone: callers, 911 dispatchers, EMT, and law enforcement, by allowing responders to focus on care rather than criminalization. As overdose deaths have begun to decline in recent years, it is critical it may not roll back or weaken protections that have helped save lives. On behalf of Maine physicians, I urge you to support LD 1646. Thank you for your time.
Thank you. Are there any questions? Yes. Representative.
Thank you, Madam Chair. So thank you for being here. I'm just, you keep using the term legally precise language in your testimony, and we've heard throughout the testimony of the day, things like magic words and specific language, specific words. And I'm just wondering, can you enlighten me and the rest of the committee what legally precise language is required according to the Beaulieu ruling?
Well, the problem with that ruling was that it suggested if someone called in and say a medical event is occurring, you must help me, that might not qualify. And so therefore that person would be at risk, as I understood it, of perhaps being arrested.
Okay, because, and I'm just trying to clarify, because I've read the case and it says specifically that the content of the call was what was important, and not, and it's, the justices specifically said that no specific legal or no specific wording was required, but it was the full content of the call. So that's why I was trying to clarify that.
Well, perhaps the full content of the call would be very brief. A medical event is occurring. I need your help. And then asking for help, and that might not qualify. I think it's very difficult to sometimes distinguish. I mean, I bet the average person might not even know there was a difference between a medical emergency and a medical event. So I think we're trying to save lives here. That's the idea. And I'm sure you feel that way too.
Thank you.
Are there any other questions? Seeing none, thank you very much. Is there anybody else that would like to speak in favor of this legislation? Online?
Rawson to turn on her mic.
Okay. Catherine Rawson?
Hi.
Hi.
Thank you. Senator BB Center, Representative Hassenfuss, and distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Catherine Rawson, and I'm the Program Manager for the Maine Recovery Hub at Portland Recovery Community Center. I am here today in strong support of LD 1646. Maine's Good Samaritan Law was passed in response to an overdose crisis that was claiming thousands of lives. Since then, calls for emergency help have increased, EMS responses have risen, and overdose deaths have begun to decline. Work has been done throughout the state to educate the public about Maine's Good Samaritan Law in an effort to combat any hesitation about calling 911 to save a life. I'm going to edit the testimony that I submitted, but it references the case that many people have referenced previously in January 2025, the decision from the Maine Supreme Judicial Court. It caused confusion, right? So yes, there's no exact magic words, but it also held that calling 911 for a general medical event was not enough. So LD 1646 fixes this by clearly extending Good Samaritan protections to calls for help, even when someone shows signs of a drug-related overdose, regardless of whether the caller uses the word overdose, restoring the law's original intent and aligning it with real-world emergencies. In 2024 alone, Maine reported more than 8,500 overdoses, with EMS responding to over 2,000. When thousands of Mainers must make a split-second decision to call 911, the law must be clear, predictable, and trustworthy. We cannot go backwards. LD 1646 preserves public confidence in Maine's Good Samaritan law. I urge you to vote ought to pass and reaffirm Maine's commitment to saving lives. I'll also, again, go off script here and add that I am a person in long-term recovery. I'm a person that has experienced overdose. I am a person that has responded to overdose. I am a person that works with the public to educate them about Maine's Good Samaritan law. And we just can't go back. We can't create confusion when I'm trying to explain to someone, don't be afraid to call 911. I don't know what you're going to run into 6 months or 6 years from now. Don't be afraid to call 911. I have lost more than a dozen people. I know that, if someone was thinking clearly and wasn't afraid to call 911, they'd still be here, right? And how many people has that impacted and affected in Maine? Like people have said, this bill is about saving lives, restoring the faith in Maine Good Samaritan law. It's one of the strongest in the nation, and we're very proud to tell people that when we educate them about this. Thank you for your time, and I'm happy to answer any questions.
Thank you very much. Are there any questions for Ms. Brosnan? Senator Searway?
Thank you, Madam Chair. Well, I appreciate your information and also, your experience. The experience, I'm just confused with this bill because it's going to put a lot more onto the law enforcement end. And I'm just wondering if it's going to be a safety issue for the people that need medical attention. That's my concern. What's your thoughts on that? Because I want to make sure people get treated. And where it's looking like they're taking medical out and putting it on the onus on law enforcement.
Yeah, thank you for the question. That wasn't my understanding or interpretation of this bill. Again, clarifying protections for people who are calling and that they don't have to use a script or say anything very super specific. So that people are not afraid to call or hesitate to call, and reducing confusion around the clarity of the law. To be frank, we work at Portland Recovery Community Center, and I know at other recovery community centers throughout the state, they work very closely and have wonderful relationships with law enforcement and their local police departments and jails and facilities and the Department of Corrections. And we appreciate and respect the work that they do. I hadn't given thought, to be honest, on how it impacts that end. I can only speak to how it relates to the work that I do, educating the public and people who use drugs and people in recovery, bystanders. I also educate plenty of organizations and businesses through the Recovery Friendly Workplace program, talking about overdose recognition, response, and reversal. And we talk about the Good Samaritan law. So I can only speak to the work that I do, educating the public and the recovery community and people who use drugs about the Good Samaritan law and how it impacts and affects them calling 911 for an emergency.
Yeah.
Representative Milligan? No? Okay. Are there any other questions for Ms. Brosnan? Seeing none, thank you very much.
Thank you.
Is there anybody else online? No, I know there's against, but is there anybody else that wants to speak in favor of this? Is there anybody? Oh, hi.
Sorry, speaking up. I do not have written. I apologize. I will submit afterwards. Good afternoon, Senator, Representative, and members of the Criminal Justice and Public Safety Committee. My name is Courtney Gary Allen. I am the Executive Director of MIRAP. We're a grassroots organization of people in recovery all across Maine working on community and public policy-based solutions to substance use. I'm also a person in long-term recovery, and a couple of times people have said that I have been helpful in the crafting of the Good Samaritan law, maybe one of the chief architects. I don't agree with that assessment, but I do agree that here in the state of Maine, I'm seen in the recovery community as one of the fundamental experts on Maine's Good Samaritan law. And I'm here to testify in favor of this piece of legislation because if I am confused by how to explain the Good Samaritan law, then most Mainers, and particularly people in recovery and folks who use drugs are confused. And so that is like the heart of why this piece of legislation is coming before you. We want to ensure that the intention of saving lives is the reality that is happening on the ground. I'm going to go straight into a couple of the questions that were asked today, particularly around the magic words and the court's interpretation of Bilodeau's case. As we've talked about, the court did require that no magic words were needed to trigger the law's protections. The court said requiring precise words would produce absurd results, and by preventing some callers and protected individuals from receiving immunity. Alternatively, though, the court also said that the medical event was not sufficient to trigger the Good Samaritan protections. And that's really where we get the confusion that we're trying to bring before you. Is on one hand, the court says no magic words. On the other hand, they say these words aren't enough. And so the idea around particularly the definition of the symptoms of overdose is to provide both the court, district attorneys and defense attorneys and law enforcement with some of the words that could be describing an overdose event. Also, while we're out training people who use drugs and family members, et cetera, to make those phone calls, the definition's intent is to provide us with the language that the court would accept when we're talking about an overdose without requiring them to say the words overdoses, but to provide a definition of what that language or content of the call could look like, that would provide them with those protections. Additionally, I think it's important to note that I think that Representative Hassenfuss really hit it on the nail with his question or statement about whether or not this is being interpreted on the subjective intent versus the objective intent of the caller. My understanding of what we need on the front lines is that while each individual caller may or may not be afraid for what happens at the scene of an overdose, may or may not be afraid of whether or not the individual is going to be charged with a criminal offense, the reality is that anytime that an individual is charged with a criminal offense, regardless of how that happens or when it happens or what happens in the particular circumstances, is that it creates a scenario that anyone who hears about that is going to have the fear that we're afraid people have, right? So anytime, an example of this is in Gardner, a couple of months ago, an individual called 911, asked for help for a scene of an overdose. The individual was arrested. The girlfriend was on the scene as well. There's questions about whether or not that person should have been immune or not immune. Within hours of that happening, I run a community center, a low-income community center. It had spread like wildfire in this community center that this person had just been arrested. And so what I mean by that is that regardless of the caller that's calling, the people that we need to be not afraid are people who use drugs. And when it happens, they become afraid. I'm happy to answer any questions, but I just want to say thank you all. I'm interested in having a conversation about how we clarify this, what that looks like, what the amendment looks like to do that. But I know at the end of the day, we all agree that the most important thing at the scene of an overdose is to save someone's life. And I also want to acknowledge that that's happening, right? We've decreased overdose deaths by 45% since the height of the overdose crisis in 2022. When you all passed the expanded Good Samaritan law, 723 individuals died from an overdose. And this year we're on track to lose 400. That's 45% decrease. And I think that's a phenomenal feat and that we need to keep going. So happy to answer any questions.
Thank you very much. Are there any questions? Senator Searway?
Thank you, Madam Chair. Thank you for bringing up the situation in Gardner. I just was wondering, how would this change that outcome?
How would this amendment change the outcome in Gardner?
Yes.
I do not have the specifics of that case in front of me right now, but this amendment seeks to address the court case and the clarity and the intent, as well as in particular, my understanding is that person was arrested for a warrant in Gardner. And we believe that warrants are covered under the Good Samaritan law and that the individual should not have been arrested. But instead of focusing on that avenue, I particularly focused on helping that individual get into treatment and recovery support services. And so that person is now in treatment and recovery support services. But I think to answer your question, the training section of this is important to me, that law enforcement, people in recovery, folks who use drugs all agree on how this is being implemented. And that would, I think it would address the Gardner situation through the training section of this legislation.
On a warrant, I believe that law enforcement officers are mandated to make the arrest as a warrant. So I think that that's something that the courts or the bail commissioner or somebody could work on that. But I'm just saying, I was just wondering how this would differ the outcome of these situations. I haven't heard of any situations other than yours so far. And so I just was.
We're happy to provide you with a follow-up on different situations that have happened across Maine and how this bill would address those concerns.
Because I'm just trying to figure out a way to make it simple so that we save lives and not end up losing lives because you're depending on the law enforcement officer to try to make the call.
I agree. I'm happy to write you a memo on different situations that have happened and how this law would, this amendment would address those. We'll follow up with that.
All right, thank you.
Representative Hassenfuss.
Thank you. And to that point of the memo, I'm curious if anybody's aware of any cases where the caller was aware that there was drug use or that it was an overdose situation, but that immunity was not offered for that situation. I don't know if Ms. Tarpinian might know that, or if that, and also any evidence, even if it's anecdotal, that this confusion on when one calls and might be immune and when one wouldn't be immune is preventing individuals from calling. So I think if you can get information on those two questions to go along with that memo, that'd be helpful.
Absolutely. We'll happy to work with the department, with them to make sure you have a memo prior to the work session.
Yeah,
Thank you. Are there any other questions? Seeing none, thank you very much. Is there anybody else that would like to speak in favor of this legislation? We have two people who would like to speak against this legislation. Oh, I'm sorry.
Good afternoon.
Good afternoon.
Long afternoon so far, but
So far.
first of all, I appreciate everybody's patience and time. And so my name is Scott Pelletier. First of all, Senator Beebe Center, Representative Hassenfuss, and members of the Joint Standing Committee, Criminal Justice. My name is Scott Pelletier. I'm the Director of the Maine Drug Enforcement Agency, representing the Maine Department of Public Safety today. I'm here to testify in opposition to LD 1646, an act to amend Maine's Good Samaritan laws regarding suspected drug-related overdose. This bill updates the provisions regarding immunity from arrest, prosecution, and revocation and termination proceedings when assistance has been requested for a suspected drug-related overdose to remove reference to medical emergencies and expand the scope to include all calls for assistance for a person exhibiting symptoms of a drug-related overdose. The bill is written, and I will say, I did not see the amendment until today, and I've spoken to the senator, and we'll get on that. So I do not bring any information about the training aspect, but I think some of the other issues I will. The bill is written, as written, would remove the term medical emergency from the statute, a term that assists 911 operators in determining the seriousness of response when dispatching medical professionals and law enforcement officers to a suspected overdose scene. I think we can all agree that someone experiencing a suspected drug-related overdose would be considered a medical emergency and requires the most expedited response available to prevent loss of life or serious injury. This bill also removes medical from the term medical assistance, leaving only assistance as a definition describing the type of call when responders would be dispatched to. I would submit to you nearly all the calls that result in a response from a first responder, whether it's law enforcement or first responders, is a request for assistance. After all, that's why people call 911, for assistance. By removing the terms medical emergency and medical from the statute minimizes the serious nature of the request and response of the first responders and implies suspected drug overdoses are no longer emergency or medical emergencies. The bill under Section 2 also provides symptoms. And I can read them. The symptom of a drug-related overdose means any physical, cognitive, behavioral condition that may reasonably indicate that a person is experiencing potentially life-threatening reaction to the drug use. I think that's important, life-threatening reaction. This includes, but it's not limited to, altered mental status, such as confusion, disorientation, unresponsiveness, agitation or paranoia, impaired or irregular breathing, such as shallow, slow, erratic, or absent respiration. Abnormal skin appearance, such as discoloration of skin tone, excessive sweating or clamminess, changes in consciousness, such as unconsciousness, difficulty staying awake, or sudden collapse, involuntarily bodily functions, such as vomiting, seizures, incontinence, or loss of motor control, abnormal vocalizations or respiratory sounds, such as choking, gurgling, gasping, or loud snoring, in any other symptom that could reasonably be associated with a drug ingestion, use, or exposure. This definition absolutely describes a number of possible symptoms, but not limited to these specific symptoms, a medical professional or a law enforcement officer encounters. These symptoms are overly broad and are frequently seen in other types of calls, not just suspected drug-related overdoses. The intent of Maine's Good Samaritan law was to save lives by limiting the enforcement of certain crimes related to those reporting and assisting someone suspected of experiencing a drug overdose, not to completely eliminate the enforcement of state laws at all, response to all calls for assistance. It should be noted, and I have not heard it said here today, but I think it's important. It should be noted after the original Good Samaritan law in 2019 and then the revised in 2022, it should be noted that Maine's current statute, if a person believes that they were charged in violation of the statute as written, that under 17A 1112 subsection 4, titled Motion to Determine Immunity, this allows a person charged to move that the court prior to trial determine whether the defendant is immune from prosecution. Once the defendant files that motion and presents the evidence to establish immunity, it flips. The prosecution has the full burden of proving clear and convincing evidence that the grounds for the immunity did not apply to that defendant. So when this law was drafted, and I can tell you there's 47 states in the United States right now that have some type of Good Samaritan law. 3 states only have Good Samaritan laws where it relates to the use of Narcan. But I can tell you, I went through it again today to find where any of those other laws had this type of immunity ability for a person that believes that they were charged unfairly or under the thing. Can't find one specifically. The majority of the Good Samaritan laws, and I credit this committee and all the hardworking people. Courtney's been working forever doing these things. And this is by far the strongest Good Samaritan law in the United States. I stand by that as 38 years in law enforcement. It is working along with all the other things that we're all doing. So, but that subsection was intentionally included in the statute to address the circumstances that may arise regarding the person's immunity status, what we're talking about now. And again, we said it many times before, the committee, the Good Samaritan law regarding this drug overdose is the strongest one in the country. And I stand by that. And I will continue to work with anybody that wants to continue to do it. One of the other things, and it was brought up a couple times, that the overdose rates and deaths, there's been over 8,000 total overdoses, not all fatal clearly, but I would submit to you that there hasn't been 8,000 people charged with whether it's possession or any other crime at those scenes. There just hasn't. And again, I'm sure the prosecutors and the defense attorney can tell you that the courts are not overloaded with people being charged at the scenes of these overdose deaths. I think another important thing to remember is when somebody calls 911, the 911 operator answers the call, 911, what's your emergency? And I get it. People, I've been doing this a long time. I understand that people are scared, they're upset. It could be a loved one, it may not be, it may be a friend or whatever. But when law enforcement is dispatched, if we eliminate a dispatcher telling a police officer, whether it's on the radio or on their computers, that it's a call for assistance, person bothering, a person laying in the driveway, without any other information, there is probably in any given time, depending on where you are in the state, I can assure you in Portland, that the officer has 6 or 7 calls backed up where he's going to go. He looks at that call and he prioritizes. If it says medical, it jumps into red, and that's the first one you go to, short of someone shooting at a bank robbery or somebody being killed. They prioritize by what information has been relayed to the dispatcher. If we eliminate medical of any kind and the dispatcher doesn't get enough information, it may, not at all times, but possibly it is going to go into a call for service that is not going to be prioritized. Not to mention, once the officers arrive on scene, if it's a medical call, they're there. That's their number one priority. And I think we've proven that by looking at the death rates. They are coming down. They need to continue to come down. But I can assure you, from someone that's been doing this for 38 years, majority of my time doing this in drug work, officers are not out there doing that. Now, there are, like the Bolia case, some would say that was the OUI case. There's a whole host of things. And I'm not going to say this doesn't happen, but what I will tell you, part of the education is the fact that our statute allows for someone who feels that they were charged and they should be covered under the immunity. There is a mechanism in our state, which most states do not have. So with that, I appreciate your time and everybody's effort in this very important message. For myself and the Department of Public Safety, I appreciate your time. I'd be happy to answer any questions. I'd be also happy to attend any work sessions that you may have. With that, thank you.
Representative Milligan.
Thank you, Madam Chair. Thank you. I forgot your name. I'm sorry.
Scott Pelletier.
Thank you, Mr. Pelletier. I heard you just say that there's an argument that could be made if a person is charged following a call to 911 where they think they should have immunity based on the Good Sam law, that they can make that argument in the courts, right? And then hopefully then it puts the burden on the prosecutor to prove that they are not immune, right?
That is what the statute allows.
Can you understand, though, that people who use drugs, who read about someone who has been arrested following calling 911 for an overdose, that has a chilling effect on people who use drugs, who then are at the scene of an overdose, and they might hesitate to call the way they would have prior to the Good Sam.
I completely, I understand that, and I can empathize with that, and I agree. But I also will tell you that the person that, it's not necessarily, this law just doesn't cover the person who called 911. When an officer shows up, the way this is written, anybody that's on the scene that technically is rendering aid, which means they could just be in the room, didn't run out. Who knows what they're doing? Those people are immune too under this statute. So I know what the perception that you're talking about. It's no different than when we do a search warrant at somebody's house. Everybody that buys from that area already knows that as well. I completely understand that, but there has to be a, a give and take on just how far do we go? And I'm not minimizing what you're saying, but what I'm saying is it's going to happen whether the person was arrested outside the house, driving away from the scene, and a policeman stops them and they get arrested for OUI, for instance. The call's still going to go back. Oh, did you hear what happened at John's house? They called 911, police showed up, somebody drove away, they got arrested. It's a valid point, but we could go on with scenario after scenario of that type of incident.
I guess I just want to reiterate something that I heard Ms. Gary Allen say, which is that, and I kind of think that got to a little bit to Senator Searway's question about the case that happened in Gardner. The ins and outs of what happened in that case and whether or not that arrest or charge was justified isn't the part that is important. The part that is important is that people who use drugs heard about that case and that it makes people scared to call 911 in the event of an overdose, which is a necessary thing to happen as quickly as possible. I've been in a room using drugs where someone has overdosed, and I've been prior to Good Sam becoming law, and it is terrifying to have to go, you flip through what's going to happen. What do I need to do to protect myself? What do I need to do to protect my friend? And those seconds are vital in saving somebody's life.
Agreed.
And this statute has done more than I think any other single thing we've done in the legislature to drive down the number of overdose deaths in this state. And it's a good thing that we have. It's one of the most successful programs, I think, that has happened come out of this administration, frankly. So I just have a hard time doing anything that would potentially put at risk people who use drugs and people who are put in those situations and have to make those really immediate life and death situations, knowing what happened in Gardner, knowing that people can be charged, and yes, they can have those charges removed. I apologize. You're right. I'll get off.
I don't take offense to it, but no,
but you can
I
understand my
totally,
point,
I
hope,
100% get what you're saying.
and we don't follow necessarily, when people are charged with crimes, a lot of people don't follow the outcome.
Okay.
Are there any other questions? Yes, Representative.
Thank you, Madam Chair, and thank you, Director Pelletier. Good to see you.
Good to see you.
If there has been any confusion in the past with the existing law, is it possible for dispatch to ask if the caller suspects if the scenario involves a drug overdose?
I think they can if they're not specifically asking. I do know they ask a number of questions depending on how receptive the caller is. I mean, they ask where the location is, what, they have a heart. They do ask those type of questions. I don't know if they specifically ask, do you think they're on an overdose? I don't.
Do you think it would be an extremely heavy lift or an unreasonable expectation to direct our dispatch to add that question in these cases?
I personally don't, but I'm not a dispatcher, but I do know that they have a book that whatever the call is, they flip it to the tab and there are a series of questions. I don't see why it's unreasonable to be able to put that on a question list along with everything else that we do.
Neither do I. Thank you.
You're welcome.
Are there any other questions? Senator Searway?
Thank you, Madam Chair. Your experience in law enforcement, do you think that by taking medical out, it will hinder law enforcement and possibly put them at risk because of trying to guess the medical situation? Could be a person even having a heart attack, but seems like they're disoriented or whatever. And we don't know, but I mean, seems like it would save lives the way we have it compared to taking medical out and trying to guess. I just think that that's putting the law enforcement in a bad spot. That's all.
Well, I would say what my response before, by removing medical again, the law enforcement officer that responds is relying on the information, the best information they can be provided by the dispatcher. So again, like I said before, if somebody calls and says, hey, some guy is, running around my backyard, whatever, and it just comes in, person bothering, if it doesn't have a medical terminology to it, again, that's not the priority depending on what the call for service. Medical the word medical event, medical emergency, whatever it is, that will drastically change the response for law enforcement. And they're only as good as what the dispatch gives them, whether it's on the radio or on their MDPs. So.
Are there any other questions? Seeing none, thank you very much.
Thank you. I appreciate your time.
Is there anybody else that would like to speak against this legislation? Please.
Good afternoon, everybody. Senator BB Center, Representative Hasselfuss, and honorable members of the Criminal Justice and Public Safety Committee. My name is Jason Mullen. I am the chief of the Auburn Police Department, and I am the immediate past president of the Maine Chiefs of Police Association. And I am presenting testimony on behalf of the association in opposition to LD 1646. The Maine Chiefs of Police Association's mission is straightforward: to strengthen the working relationships among Maine's police leaders, to promote professionalism and consistent standards across the state, and to support the men and women who serve our communities every day. At the heart of that mission is a shared commitment to protecting life and property and upholding the values of our profession. Our association has supported the Good Samaritan Law enacted in 2019 because it encourages people to call for help during an overdose while still allowing law enforcement to conduct an appropriate investigation. That law provides an affirmative defense for both the person experiencing an overdose and the person seeking medical assistance, and it has worked as intended. LD 1646 goes well beyond that framework. Our concerns align with those raised by the Maine Department of Public Safety. The bill expands immunity to situations where a person is merely exhibiting symptoms of a drug-related overdose, using criteria that is so broad that it could apply to many unrelated medical conditions or to victims of violent crime. Officers could encounter someone who is unconscious, injured, disoriented, and be required to assume immunity before determining whether or not a crime has occurred. This creates real risk for victims who need protection and for responders who must make quick, informed decisions. Current law already provides a clear process under 17A, section 1112, subsection 4, allowing the court to determine immunity after investigation. LD 1646 would instead preempt that investigation, effectively requiring officers to rule out immunity before they can even assess what happened. We fully support the efforts to save lives and encourage calls for help, but LD 1646 introduces unintended consequences that undermine public safety and hinder the ability to protect victims. And for these reasons, the Maine Chiefs of Police Association respectfully urges the committee to oppose LD 1646. Thank you for your time and consideration. I'm free to answer any questions.
Thank you. Are there any questions? Yes, Representative Perkins.
Thank you, Madam Chair. And thank you, Chief, for being here. Can, for my benefit, the benefit of the committee, can you just, you mentioned unintended consequences. Can you expand on that a little bit for me?
As far as,
well, what might some of those unintended consequences be?
Well, because if we respond to a scene where somebody is lethargic or could be in an altered conscious, that might be a heart attack. That could be a head injury from a violent crime. We don't know what that is until we delve into it. But if we are forced to determine whether or not there's an immunity takes place, if somebody's displaying those symptoms alone, it might not be a drug overdose, but it's a symptom. Are they now immune from prosecution for a crime that might be committed in that presence?
Okay. And if I may
Follow up,
question.
follow up, Chris.
So you've noticed you've been sitting here through the all of the proceedings this afternoon. Can you give me the association's take on how the Boyer case, which has been bantered about, how your association feels that case is affected? Well, how we currently use the law?
Well, the case involved, the Boyer case, doesn't involve a 911 call, and it does not involve a suspected drug overdose. That involves a OUI where the person was charged and found guilty of operating under the influence of drugs. They then tried to seek immunity for that offense, saying that it was a medical event or a medical emergency, when it was not. It was not a medical emergency. The subject was parked on the side of I-295 in the left-hand shoulder before the Brunswick exit. Car goes by, sees them parked there, says, that's strange. 2 hours later, goes by again and still sees the car there. They then drive to Brunswick PD, talk to an officer in the parking lot, say, yeah, there's a car parked on 295. It's in a weird spot. I don't know if it's a medical event. You might want to check it. Officer responds, has interaction with the subject, determines the subject is under the influence of drugs, does field sobriety tests on that subject, determines probable cause to charge that person and take them into custody for criminal OUI. They bring them to the Brunswick Police Station, do the paperwork, release them on bail. Doesn't involve a 911 call, does not involve a drug overdose. Folks, I've been a police officer for 30 years. If somebody is overdosing on drugs, they don't have the capability to submit to field sobriety tests. They don't have the physical capabilities to be able to do that. So the courts ruled that in this case, this is an OUI that does not involve a medical emergency. The subject was never seen by EMS, and it does not involve a 911 call. That's why they did not grant immunity for that case.
Senator Searway?
Thank you, Madam Chair. A case was mentioned about Gardner, about a warrant for an arrest. What's your understanding on Good Samaritan law when it's called in? They have a warrant.
Under the Good Samaritan law, warrants aren't as part of that excluded list. And as a police officer, when we're presented with somebody that has a warrant for their arrest, we're required to take action.
That's great. Thank you.
Yeah.
Are there any other questions? Yes.
Thank you, Chief, for being here.
Sure.
Sorry I introduced you. However, you've been on the 911 committee for a long time.
Correct.
We do have a protocol there with a series of questions that the dispatch will ask the individual. That information is transferred to, I believe, it may be wrong, but I believe every unit responding to that call. Am I correct?
Yes. One of my past assignments has been chair of the Lewis and Auburn 911 committee that oversees the operations for Lewis Auburn 911 Center, which is one of the busiest call centers in the state. It's called a medical emergency dispatch. There's a protocol, EMD protocol, that as a 911 call comes in, they start asking a series of questions. Based upon those answers, that may split off into another section of the EMD. There is a section that addresses overdoses in the emergency medical dispatching protocol. If the dispatchers going down that road, they go to that section, they go through the series of questions regarding the overdose potential. And if they determine it's an overdose, they will broadcast that to the responding units. So it could be as simple as man down. That might be more than they are actively overdosing. Might be caller information saying that they have knowledge that the person is actually overdosing. But it can run the gamut from a simple person down to that detailed information. And the officers, their first priority when they get on scene is life safety. Doesn't matter what kind of call it is. It could be a burglary in progress. It could be a criminal trespass. Their first responsibility when they arrive on scene is life safety. And if they have somebody that's in jeopardy of life safety, they're going to stop what they're doing and address that as long as it's safe to do so. In 2025, armed police officers administered Narcan 43 times. That's potentially 43 lives saved. Most of those are based on 911 calls. So the system as it currently stands is working, and it's working effectively.
Representative McIntyre? Oh, I'm
Follow-up,
sorry.
if you don't mind. Looking and studying the bill as you have, and as I have, do you see any end product where both sides could come to an understanding as to I don't think it would, I don't think it would completely respond to the problem. However, we would be extremely close. You and I have worked on many things.
Sure.
And we've dissected so much information to get to a point where both sides tend to agree to go into one direction. Do you see any light? Yeah.
Potentially, I'd have to do some more research on it. I'd be willing to attend any work sessions to come up references and try to see if we can come to some kind of resolution on it. But as the current law stands, it's working effectively. And by removing this language of medical emergency or medical event, I think you're opening it up for some wide interpretation that could put people in jeopardy.
Okay. May I ask if, when we do have a work session, could you look up and or try to help me out with this?
Sure.
An answer as to, is there a potential for us to come to a conclusion where we may, neither side may be satisfied. However, both sides will agree to go into one direction that should help the individuals that we're looking to help.
Certainly, I'd be willing to come alongside you and work towards that.
Thank you. I appreciate it.
Representative McIntyre.
Thank you, Madam Chair. For the work session, and I hope that this is not too deep of a data dive. But I did not know your background in terms of your connection to the 911 or 911 committee function. Can you, and imagining that 911 calls are categorized, cataloged somewhere by type, are you able to paint us a picture as to whether or not there has been a reduction or increase in the number of category calls, relevant category calls, before and after the case that has been cited today? Is that too deep of a dive?
I could probably do it for the Lewiston 911 Center. To do a statewide, that's way too much for me.
Then let's contain it to that.
Sure.
Thank you.
Are there any other questions? Seeing none, thank you very much.
Thank you.
Is there anybody else that would like to speak against this piece of legislation? Are there still people online?
Christopher Martin needs to turn on his camera.
Okay. Christopher Martin, can you turn on your camera? Mhm.
Yes.
Okay. Shira Burns, is she still on?
Okay, so he needs to be on.
Shira Burns, can you, oh, okay.
Yes. Senator Beebe Center, Representative Hassan-Fuss, and members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Shira Burns, and I represent the Maine Prosecutors Association. We are submitting testimony in opposition of LD 1646. So this bill would expand the scope of the Maine Good Samaritan law in two significant ways. It would remove the reference to the medical emergency in the initial paragraph, and it would include calls for assistance for a person exhibiting symptoms of an overdose that come with a very broad definition of included symptoms. I didn't have the amended bill when I drafted this testimony, but removing the requirement for a call of medical emergency and including calls for assistance for a person exhibiting symptoms of a drug-related overdose will provide immunity to many situations that do not involve a drug overdose. This bill only requires a call for assistance for situations for persons exhibiting symptoms, and then defines those symptoms broadly. Even in the new amendment, I did quickly read it. This could still include a call from 911 where a victim states that she's come downstairs and someone is on their couch snoring loudly. If all the elements of the crime were met, this could be prosecutable pursuant to the Maine's burglary statute. However, if this bill became law, this person may be immune from prosecution, even if the person had never ingested drugs and the victim of the crime wanted this person prosecuted for the illegal entry of their residence. The victim was not concerned about a medical emergency, but was just literal in what they were witnessing when speaking to the dispatcher. And if you look at the analogy I'm talking about, it's because the person called 911 for assistance, saying someone was loudly snoring. Now, again, that was in the prior bill and that was taken off. But if you look in the bill that still stands, there's still a catch-all provision that says any other symptom that could reasonably be associated with drug ingestion, use, or exposure. Now, if defense gets a medical person to say, well, loud snoring can be a symptom that's reasonably associated with drug ingestion, use, or exposure, then this person is going to get the immunity from the statute. So when the bill's definition of symptoms of drug-related overdose has that catch-all phrase, it's going to catch a lot more than maybe what this bill was intended to do. It does not require that it is a symptom of drug-related overdose, only that it reasonably could be associated. So effectively, all these symptoms in the catch-all provision would provide immunity to many calls that have nothing to do with drug overdose. So the purpose of the Good Samaritan law, as I read it, was to have people call for help when someone was experiencing a drug overdose, who otherwise would not because of fear of prosecution. As much as this law is being used for that purpose, we see it for other purposes not as noble. The law has been changed multiple times now to exclude more crimes, and like we talked about recently, the OUI crime is because it started to be used to protect people that were under the influence, both on alcohol, not even on drugs, but OUIs of alcohol and drugs while driving. So the more we broaden this law, the more ability there is to have it applied in situations that were unattended. And a lot of people have talked about the law court case of Bellio. I have absolutely read it. The law court was clear. It's not about magic words, but is about the caller must suspect that's a drug-related overdose. And this bill is trying to fix that. But I guess I don't understand what the fix is, because if you want it to expand it just to any medical emergency, then what are we protecting? People aren't scared to call 911 for a heart attack. That actually happens a lot of the times. So I think it starts to be overbroad, and the point of it being related to an overdose is because of the criminal penalties that come with the use of drug use. So for those reasons, the Maine Prosecutors Association is against this bill.
Thank you. Are there any questions for Ms. Burns? Senator Searway?
Thank you, Madam Chair. Thank you for coming on. I got a question. How do you feel that this will, do you feel that this will make it tougher in law enforcement as far as their responsibilities? And also, what do you think about the 2-hour trainings that this is requiring for law enforcement?
I mean, I can speak more on the prosecution side. I mean, for law enforcement, we do, and I think maybe some law enforcement's maybe testifying looks after me about they're responding to a lot of medical calls that have symptoms that can be related to overdose that are not overdose. So every time they do this and then there's some kind of criminal activity on the scene, they're going to have to sparse out then, can we make an arrest based on it? So I actually think this may lead to more confusion than what's currently law with the law court actually has clarified. Does the caller suspect that the drug-related overdose has occurred? I mean, that makes it actually very clear on what the law is. And then as far as the training, I'm not going to speak. I can't speak to that. That I'm just not a specialist in what law enforcement does for training and how that's delivered.
Yeah.
Are there any other questions for Ms. Burns? Seeing none, thank you very much.
Thank you.
Christopher Martin? Are you Christopher Martin?
He's good.
Could you unmute your microphone?
Can you hear me now?
Okay,
hear me?
are you Christopher Martin?
I'm Christopher Martin. Yes, yes.
Okay,
Okay, so I'm good. I've completely mucked this whole technology thing up. I apologize. Good afternoon, Senator BB Senator, Representative Hassan Foss, honorable members of the Criminal Justice Public Safety Committee. I'm Christopher Martin. I'm the Chief and Public Safety Director for the City of Brewer, and I'm here to testify in opposition. We're getting late into the evening. I'm not going to belabor all the talking points. I gave you electronic testimony today that you have access to, which I've done a breakdown and kind of illustrated what would happen if this bill passes as it's written. So with that being said, I just want to illustrate a couple concerns that I have for your deliberation. And again, if you want to do a deeper dive into what I'm fearful may be the result of this bill passing, it's all documented for you in my testimony. You should all read the State versus Bowyer opinion. It's not a long read. It'll take you about 5 minutes. But today we've listened, and what we're hearing is the genesis of this concern or emergency or crisis is a result of this recent law court decision. I think if you take the time and you read this decision, you're going to find that we're talking apples and oranges, and that the law court felt that the statute was unambiguous and that there really wasn't any confusion as to intent, and there was no requirement for special words. But anyway, make your own assessment, read it. It'll take you about 5 minutes, easy to find online. Out of the way this bill is written, if things don't change, there's going to be two things that'll be exploited here. Number one is going to be, how do we define a call for assistance? And number two is when we get into the definition of symptom of drug-related overdose. So I'm going to drill down on both. Currently, if we don't have a better definition for call for assistance, this can be interpreted as any call for law enforcement. So this may be a shoplifting call. This may be somebody sitting under the bridge call. This may be any type of responsive call, because we've removed the moniker from medical. We've taken that out. So it could be any conceivable call that we're being sent to, emergency or non-emergency. And it doesn't have to be a call that is solely about a concern for person overdosing. So the next thing we have to drill down on is when we look into the definition of symptom of a drug-related overdose. If it stopped there, it's pretty clear, right? But on that last sentence, the last sentence is a catch-all, and it closes like this: any other symptom that could be reasonably associated with drug ingestion, use, or exposure. Now think about that. Any other symptom that could be reasonably associated with drug use or drug ingestion. That's not talking overdose. So now we're going to apply this definition of somebody is under the influence of drugs, not overdosing, and PD gets a call for assistance, shoplifter in custody, somebody's under the influence of drugs, under this language, immune from prosecution. Think about the open air drug use in public spaces. Think about indecent exposure. Think about essentially what you will have is a de facto decriminalization bill, not just for drugs and drug offenses, but also for drug-related crimes associated with use and abuse. It'll blow the floodgates open unless we pin down and clarify those definitions. So anyway, if you could please keep that in mind as you deliberate. I think the reasonableness standard as law enforcement, as we get to a scene, it's not just about being dispatched to a scene. We may get there and we determine we have a medical event or an overdose, and it's the totality of the circumstances analysis. And I don't see any confusion on the law enforcement end of things. And I haven't heard of any poor decisions that's creating this crisis. If we're trying to have legislation to fix people who are hearing inaccurate information through rumor mills, through the recovery community, passing this legislation isn't the fix for that. So anyway, respectfully, thank you for giving me some time and allowing me to make a couple points, and I hope you all drive safe tonight.
Thank you very much. Are there any questions? Seeing none, thank you.
Good night. Thank you.
Do we have anybody else online? Is there anybody who would like to speak neither for nor against this bill? Seeing none? Okay. What? Yes. Sure. Yeah, we will. So we're now going to move to LD 1962.
Okay. I thought we were doing it last. I'll have to let Senator.
That's her. She's here. Pardon? Senator Doosan.
I have representative.
Okay, and we're going to use the 3-minute timer. Generally, our testimonies are supposed to be limited to 3 minutes. And 3 hours later, obviously I made a mistake. So. We have a timer here.
I don't have the computer here, so.
Oh, it's right there.
Can't we use that timer? We used to have a timer right there.
Can they do this one? I like this. Whichever one you like.
The people can see this.
People can see this. They can't see that.
Just signed up, I think we were.
Then signed up. Oh, interesting. Okay.
I didn't hear it.
So, Bernice, how do we turn that on?
I just have to hand you the.
Okay.
It's not the question. I know, that's why I don't like computer. So.
Okay. How do we do this?
Are we ready to roll? We don't think to roll or, because there's no time. We'll wait for that.
It's not coming on.
This, I don't know.
Is Will back? Will's not back.
And if we say more than, what should it be? If you make more than 2 sentences before your question, you have to buy.
Will, okay.
Do you have? And I will. And you've got 2 sentences. And then they're asking me questions. There's not.
So
You gotta bring goodies.
it's going now. So how do we do it?
I can do this one until we can start. There's no timer for this deal, which is the legislature.
Senator Doosan, do you want to introduce the bill? And you don't
Thank-
have a time limit.
Well, I only have 16 pages of testimony, but
Yeah.
I'll cut it down. Good evening.
Good evening.
Chair BB Center and Chair Hassan Fuss. Thank you, and members of the committee, thank you so much for your patience. I certainly see and appreciate how much you're having to manage in terms of keeping the hearings going and keeping us all alert. My name is Jill Duson. I serve as the Senate Assistant Majority Leader, and I have the privilege of representing Senate District 27, which includes part of Westbrook and part of Portland. Thank you for the opportunity to present LD 1962, an act to establish a corrections ombudsman. Having served as the long-term care ombudsman for the state of Maine, I have a particular affinity for the role of an ombudsman to act as a neutral, independent check on public institutions and systems, to investigate complaints and mediate disputes, to ensure fairness, accountability, and transparency, and to recommend systemic improvements in the administration of public programs. The focused intent of the office proposed by this legislation is to investigate, analyze, and perform trend analysis of institutional practices and services administered through the Department of Corrections, and recommend changes in policies, procedures, and practices to achieve continuous improvement in corrections systems outcomes. Unlike the Maine Department of Corrections Board of Visitors, the Corrections Ombudsman Office would be charged with receiving and investigating complaints submitted confidentially by staff, residents, or the general public. Through LD 1962, Maine has the opportunity to join 19 other states, which according to the nonpartisan National Conference of State Legislatures, have a prison oversight body that meets 8 key requirements, including a full independence from the correctional agency that they oversee, having the right to access correctional facilities, and are set up as a permanent body. Now, you might wonder, doesn't Maine already have some structure for oversight of our state corrections system? We do. But I'm concerned that a considerable amount of our public dollars are being spent not in rehabilitation services for the incarcerated or for corrections employee support, but instead to settle suits initiated by incarcerated persons or their families following release, with a view to compensating them for experiences suffered during incarceration. These settlements have run into millions. As an independent assessment of how things are being done could lead to a new and better proactive approach. Independent assessments can be particularly useful in improving care of dependent populations. I want to be sure to acknowledge that our Department of Corrections is known nationally as one of the best in the country. But being known as one of the best is not a good reason for not furthering our mission of oversight. And this proposal provides us the opportunity to build on the good work already being done. Because we have a good Department of Corrections, we anticipate rapid proactive improvements through the work of the Ombudsman Office. It is extremely rare for anything to improve solely as a result of self-examination. Rather, systems improvement almost always occurs in the setting of independent evaluation followed up with recommendations. In Maine, we pride ourselves on a transparency, taking the view that taxpayers are best served by knowing how their dollars are spent, and welcoming public consumer input to provide guidance and ideas to the state for improvements. An incredible group of advocates will speak in depth on why this new approach is needed. They will touch base on various challenges that mark our current approach to incarceration in Maine and how a corrections ombudsman office can identify improvements that will make things better for staff, for residents, and for the Maine taxpayer. I thank you for your attention to this bill and all the time that you've put in today. A very long first day for our legislature. I'd be happy to answer any questions, but I also will admit that there are others ready to testify who may have better answers to your questions.
Thank you, Senator. Have you signed in? Did you
I
sign
will
in?
make sure I do that, ma'am.
Are there any questions for Senator Duson? Yes, Representative McIntyre.
Thank you, Madam Chair. Thank you, Senator Dusan, for the testimony. I'm looking quickly at section 3 of the bill. Subsection C, where it talks about people disqualified from applying for appointment. Can you offer any insight as to what your foundations were for items 1 through 4 as to who cannot apply to the jobs? Which is at the top of page 2 of the bill, if you have it. If you don't, I have a copy right here.
I have a copy of the bill.
Okay.
Thank you, sir.
Yeah.
With your indulgence, I would defer that question to the folks who will be coming behind me.
Very good. Thank you.
Are there any other questions? Senator Searway?
Thank you, Madam Chair. On the ombudsman's, you know, I've had experience with several ombudsmans.
Yes, sir.
In a situation on a big project, and every time things got bad, person ended up disappearing, they got somebody else. And it's because they didn't like what the outcome was coming. And so how's this going to help on either side? Because it sounds like this is more of a political position than it is of professional of what the organization is doing. I'm just kind of trying to differentiate on because we have to go by DOC guidelines and whatever, and you know, and when jails do, the prisons do, and then when you get an ombudsman that's trying to make a I don't know what an in-between type thing, it may not follow the DOC standards. And that's what I'm wondering how that's going to work.
I'd be happy to answer in the context of my own experience serving as a long-term care ombudsman for the state of Maine, which was a position that performs this kind of work in the nursing home and long-term care industry for Maine. And I think Brenda is still the long-term care ombudsman for Maine. The ombudsman role is decidedly unpolitical, is designed to be non-political. It is a systems review, so receiving complaints from confidentially or not confidentially is a part of the process that allows the ombudsman to pursue the complaint, but evaluate it in terms of whether the system is following already approved systems guidelines. And if a series of complaints come in that are in the same subject area, the ombudsman office is able to identify trends and then report those problematic trends to the Department of Corrections, to Health and Human Services who are overseeing nursing homes, report those trends as issues to look at from a systems implementation angle, not from a individual Bob Jones had this problem or a Mrs. Johnson whose mom is in a nursing home had this problem, but instead presenting a trend analysis that we've gotten 15 complaints from family members who are saying that I give you a really easy example. In nursing homes, the residents are supposed to get $25 a month in personal care needs funds to spend however they want. We were able to identify a trend that the residents were simply not getting those monies. But we didn't pursue it as a complaint by complaint issue. We presented the trend to the department, and the department upgraded its audit process to gather data on whether residents were getting that money. And the nursing homes then were able to comply with the updated audit information. And the problem was resolved without residents of a nursing home who are completely dependent on the system that they're living within, much like residents of a corrections facility are completely dependent on the folks who are running the system that they live in.
Yeah, thank you.
Did that make any sense?
Are there any other questions? Seeing none, thank you
I
very
appreciate your
much.
time. Thank you.
Okay. Is there anybody that what we're going to do is we're going to put this clock on. It's going to be 3 minutes for testimony. Is there anybody that would like to speak in favor of this bill? What the heck will do this?
Good evening. Well, yes, it's evening now. My name is Susan Feiner, and I'm here to speak in favor of this bill by reading a letter that was written to the Joint Standing Committee on Criminal Justice and Public Safety. And thank you, representatives and senators, for having this hearing. My name is Santanu Basu, and I respectfully submit this testimony in strong support of LD 1962, the bill to establish an independent corrections ombudsman in the state of Maine. LD 1962 represents a necessary and long overdue step toward transparency, accountability, and public trust within Maine's correctional system. An ombudsman does not weaken public safety or undermine the work of corrections staff. Instead, it strengthens the system by ensuring that concerns are addressed fairly, consistently, and independently. Currently, incarcerated individuals, their families, and even staff members have limited options for raising concerns without fear of retaliation or dismissal. Internal grievance systems often lack independence, and for many, they feel inaccessible or ineffective. This creates a gap between policy and practice, perception and reality. An independent ombudsman helps close that gap. The presence of a corrections ombudsman would provide a neutral and confidential avenue for complaints and concerns, identify systematic issues before they escalate into crisis or litigation, improve conditions of confinement, and increase public confidence through transparency and oversight. Maine has an opportunity to lead with integrity. States that have implemented independent oversight have seen improvements in accountability, safety, morale, and outcomes. Oversight is not about punishment. It is about learning, improvement, and responsibility. I urge this committee to, I skipped a paragraph. For those directly impacted by the correctional system, an ombudsman represents dignity and voice. For family, it assures reassurance. For staff, it provides a mechanism to raise concerns without undue risk. And for the public, it ensures that Maine's correctional system reflects our shared values of fairness, humanity, and justice. I urge this committee to support LD 1962 and move it forward with an ought to pass recommendation. An independent corrections ombudsman is not just good policy, it is good governance. Thank you very much for your time, your consideration, and your commitment to a safer, more accountable Maine. Thank you.
Thank you. Are there any questions? No questions.
I couldn't answer them anyway.
Thank you very much. Is there anyone else that would like to speak in favor of this? Okay, so we're restarting. Yeah. Thank you.
Senator Beebe Center, Representative Hassan Fuss, and members of the Criminal Justice and Public Safety Committee. My name is Lonnie Graham. I'm a physician and former Chief Public Health Officer for Maine. I'm submitting this testimony in support of LD 1962, an act to establish correction ombudsman on behalf of the Maine Medical Association and the Maine Osteopathic Association. Immediately after I completed my internship, I worked for a year in the Massachusetts prison. One day when I was working, a young man was brought in by guards who had clearly received a number of severe blows to the head. His head and face were covered in blood. When I asked him what had happened, he said he had fallen downstairs. I thought he was making a joke. He wasn't. He stuck to his story, even in the face of potential brain damage. He was afraid to say what had actually happened to him for fear of retribution, either from a guard or from a fellow inmate. LD 1962 is a process by which such fears are removed. An inmate, a correctional employee, or a member of this body can raise concerns confidentially without fear of retribution. Complaints can be investigated, and if indicated, changes made to policies and procedures. It is well known that people who are incarcerated and those caring for them have shortened lifespans. Life expectancy for a correctional officer is significantly lower, often cited as around 59 years, which is about 16 years less than the general U.S. population, largely due to extreme workplace stressors. And incarcerated people also die younger than the average Mainer. Isn't it our responsibility to try every option to improve these dismal statistics? Every system only reaches its highest and best performance through consistent examination by unbiased observers. This is true of everything from business ventures to elder care to health care to foster care. All of those systems are subject to independent oversight. Working without that benefit, as the Maine Department of Corrections has done since its inception, has many disadvantages. The Maine correctional system has deservedly been held up as a model for other state systems. However, many developed nations have more successful systems. Critical observation of work is the price of improvement and of getting the best, the most efficient outcomes. We hope that this legislature will see the value of that timeless principle. We in healthcare and public health hope you will support 1962. Thank you for your time. I'd be happy to answer any questions.
Thank you very much. Are there any questions? Yes.
Thank you, Madam Chair. Thank you for your testimony. You say that many developed nations have more successful systems. So for the work session, can you provide us with the data that supports that?
Sure,
Unless you
sure.
have some comment today as to why you believe that's true.
No, that wouldn't be a problem. I'm sure we can do that.
Thank you.
Are there any other questions for the doctor? Seeing none, thank you very much. Thank you. Is there anybody else that would like to speak in favor of this bill? Do we have people online? Hi.
Well, Bernice.
Come on.
Senator Beebe Center, Representative Hassan Fuss, distinguished members of the committee. My name is Peter Lehman. I live in Thomaston. I'm a formerly incarcerated citizen and a person in long-term recovery. It's good to see you all. I'm testifying in behalf of the Maine Prisoner Advocacy Coalition, whose goal is to promote restorative practices in order to increase public safety and the health of our community. While I was in prison, I was a counsel substitute for more than 4 years. A counsel substitute is a resident or designated staff member who assists residents who have been written up for disciplinary infractions, kind of their informal, non-professional lawyer. Duties include helping the prisoner understand the charges, navigate the disciplinary process, and assist the prisoner during the formal disciplinary hearing, and ensure they receive a fair process and ensure the prisoner's rights are upheld according to departmental policy. Back in those days, there was an Office of Advocacy inside the DOC with a professional paid inmate advocate physician who trained and supervised counsel substitutes. I was trained by the head advocate, Wes Endrichson, working out of the DOC's central office. And at Bolduc, I was supervised by inmate advocate Ann Rourke at MSP. One reason for proposing an ombudsman bill is that this Office of Advocacy and these inmate advocate positions no longer exist in the department. But there is precedent for this sort of oversight in the DOC as in other main departments. Beyond the individual disciplinary cases and individual grievances, the Office of Advocacy was in the position to see patterns of difficulty. What I'm trying to say to you is that 25 years ago, there was more oversight and inmate advocacy in the department than there is now. Not a lot, but some. And there is good precedent for having that oversight. I want to also point out that individual disciplinary actions and individual grievances are focused on specific circumstances, not on patterns. And as Senator Dusan pointed out, one of the things that Ombudsman is looking for are patterns and looking for not confrontation, but ways to solve problems. And it's that problem-solving oversight inside the law enforcement. I look at Senator Sirway and I realize that inside that the board of the academy serves that function inside the law enforcement community. And you can think of that as the same kind of oversight, looking for patterns and looking for that kind of process. So while the system we had 25 years ago was better than nothing, it's not the unbiased confidential program proposed by this bill, which could at last make real difference in improving Maine's prison system. Please vote. Please vote to support this bill and establish the Corrections Ombudsman. Thanks for your attention. I'll
Thanks,
answer
Mr.
any
Lehman.
questions you
Are
have.
there any questions for Mr. Lehman? Yes. Representative?
Thank you, Madam Chair. Referring to your testimony, first page, one reason for proposing an ombudsman bill is that this Office of Advocacy. Did you have any involvement in the writing of this or the drafting of this or the advocacy for this bill? Direct involvement? Because the sponsor referred me to people behind her to address my first question.
Oh, yes, I did.
Okay, so then I'm
I
gonna
understand your question,
All right.
that I helped draft this bill.
an additional question.
Okay.
Yes, did you help draft this?
Yes.
Okay, thank you. Referring back to section 3, subsection C, a person is disqualified from being appointed to the position of ombudsman if, and then there's 4 exclusions.
Yes.
Can you provide any insight as to the foundations for those exclusions?
Yes, those are pretty typical exclusions to prevent conflict of interest.
Typical based on,
Typical based on other boards, other kinds of activities that you might have. If you wanted to have a oversight for the nursing industry, you would probably not have a person who was heading up that, who was in fact the director of a nursing association.
okay, thank you.
Does that make sense?
You have provided me the insight I needed. Thank you.
Okay. It's the conflict of interest that I think is the key to that.
Are there any other questions for Mr. Lehman? Seeing none, thank you very much.
We're all tired. Thank you.
Is there anyone else that would like to speak in favor of this legislation? I'm going to start the 3-minute clock again.
Can I give copies?
My name is Luca Mellon. I live in Rockland, and I'm testifying in support of LD 1962. Carceral facilities need oversight because they're isolated from the public eye and because they house many of our community's most vulnerable. In what follows, I will describe how neither our prison boards of visitors nor prison accreditation process provides meaningful oversight currently. Maine's Prison Board of Visitors have submitted only 15% of the annual reports required to be submitted to this committee over the past 15 years. Of the most recent round of reports due, only MCC's was received. Half of our prisons don't list a way to contact their Board of Visitors, and half that do offer the facility's mailing address. This means that fear of retaliation could keep some prisoners from reaching out about these issues. It's concerning to me that people who've been incarcerated for over 15 years at Maine State Prison have never heard of the Board of Visitors. So what about national accreditation? Does that help with prison quality control? The DOC contracts with ACA to perform required facility reviews every 3 years. These reviews aren't helpful for external oversight because the DOC policy considers them confidential. Only 1/3 of Maine State Prison's 2019 review included actual findings about this facility. 48 prisoner contacts are summed up in 2 sentences. Likewise, 92 staff interviews in this audit fit into an additional 2 sentences. The report doesn't list the 60 mandatory standards that this facility is subject to, or how we did on each one of them. The issues that these structures fail to prevent end up manifesting themselves in court. I'm just going to show the documents as I refer to them. At least 28 cases were filed by prisoners against the Maine Department of Corrections in 2025, after 27 had been filed in 2024. 10 of these cases were Maine Human Rights Commission cases. Even when residents file and win accountability through the courts, some have had to refile because the department failed to comply with the resulting judgments. A functional ombuds office would prevent these cases by supporting prisoners, staff, and administration, while relieving pressure on our courts and the Attorney General's litigation arm, which defends the department. Unfortunately, media coverage hasn't helped shed much light either. Multiple longtimers at Maine State Prison report that the current months of lockdown are the worst they've seen in decades, with no end in sight. The only press coverage I can find is a 130-word article last month that features the department's spokesperson's denial of lockdowns and no inmate perspectives. I wouldn't testify on this bill if our prisons didn't have issues. It's not unusual right now to see Maine State Prison residents attending events on Zoom wearing jackets and hats because their rooms are so cold. The DOC's medical provider WellPath filed for bankruptcy in 2024 and had to sell off part of itself in order to pay back some of the prisoners they owed settlements to. The average age of death in Maine's prisons, the last 4, is 61 years of age, which is 17 years younger than the rest of us.
If you could finish.
These issues can be resolved with collaboration, transparency, and external oversight. The 2,000 people in DOC's custody, their friends and families, the department's employees, and Maine's taxpayers deserve an ought-to-pass vote on LD 1962. Thank you.
Thank you. Are there any questions? Seeing none, I hope you'll come to our work session. Is there anybody else that would like to testify?
Hello, my name is Christine Hay, and I'm here to read a letter written by Sarah Johnson. And thank you, Senator Beebe Center, Representative Hasselfuss, and distinguished members of the committee. My name is Sarah Johnson, and I am a Sanford resident writing in support of LD 1962. An act to establish the Corrections Ombudsman. I have 40 years of experience in manufacturing and 21 years working as an educator in the carceral system, including 4 systems full-time in a southwestern prison. My work has consistently shown that safety, efficiency, and improvement are driven by data. Maine already uses ombudsman offices to protect vulnerable populations such as children and those in long-term care. Incarcerated people are also a vulnerable population. A corrections ombudsman's would support the Department of Corrections mission to reduce harm through supportive intervention by providing independent, confidential investigations and recommendations. This office would improve safety, save money, and strengthen the Maine model philosophy. Lawmakers are able to make more informed policy and funding decisions with insight provided by an oversight body that conducts routine inspections, investigates allegations of systemic problems, collects and analyzes data, reports its findings, and makes recommendations. Maine taxpayers have recently paid settlements in a number of lawsuits. Some of the settlements are $400,000 for staff discrimination settlement, $115,000 for excessive pepper spray, unknown amount for a solitary confinement that also resulted in policy changes, $225,000 for a wrongful death lawsuit of a teenager, medical treatment provided for people suffering from chronic hepatitis C, current lawsuit relating to rights violations during pregnancy. A safe, independent Office of Ombuds would have prevented the issues that led to these lawsuits, saving tax dollars, staff time, and human suffering. Regarding cost, the Maine DOC is the largest recipient of any state agency of overtime pay, receiving 26% of the state's overtime pay in 2024, while representing only 8% of state employees and regular basic wages. Corrections officers also suffer an overworked and stressful environment. COs disproportionately experience higher rates of physical health problems, such as chronic neck, back, and knee injuries, health disease, diabetes, high cholesterol, and hypertension, compared with crisis counselors and law enforcement personnel.
Could I ask you to finish?
Oh, the mental and physical strain of the profession can lead to an even graver consequences. The suicide rate for COs is 39% higher than any of the general working population. A work environment this stressful could be one of the least amount of overtime, not the most. There are many reasons to support a law increasing transparency at Maine's Department of Corrections. The DOC serves a vulnerable population under challenges conditions, and the Ombudsman Office is meant to support this work. High employee overtime and costly lawsuits to divert taxpayers' dollars from the effective operations of incarcerated people at the DOC and Maine communities. Have members of this committee had opportunities to speak directly with staff and incarcerated residents about policy concerns, healthcare access, or the grievance process? These conversations will provide valuable context in the advance of the work session on LD 1962. I urge you to vote ought to pass.
Thank you very much.
Thank you.
Are there any questions? Being none, I hope you'll come to the work session.
Thank you.
Is there anybody else that would like to speak in favor of this legislation? Yes, me.
Oh, okay. So I'm gonna be referencing this, even though it might be online. No, it was okay. Oh, of course, there it is. Do that. Just, okay, yeah.
Will you be able to keep it to 3 minutes, you think? Do you think? You. That's the yellow one, 3 minutes.
Excuse me, I have a couple other things to pass out. Okay. I just want to preface my testimony with the fact that we got testimony from several people who are incarcerated. And of course, they are not allowed to speak before this committee. So I'm passing out some of their testimony to you for your, because I'll reference it. I also want to preface my testimony by saying that the Department of Corrections is recognized.
Do you want to stand so we can make sure that you're?
Okay, sorry. The Department of Corrections is recognized across the country as one of the leaders in corrections, and that goes without question. The Department of Corrections has also gone to European countries to look at how other people do it, to see if there can be improvements. And the bill itself that was written, in doing so, the folks who worked on the wording looked at 16 other states that have ombuds bills. So a lot of the wording was part of those 16 other states' bills. So first of all, recognizing that the department is a leader in this area, I want to point out that Gordon Perry's testimony, which is before you, also states that, as Shantanu Basu's testimony did. And then they go on to say why it is important to have an ombuds just the same. I am going to be giving specific examples in my testimony. Examples are not trends. An ombuds would be able to figure out whether they are trends. Senator Beebe Center, Representative Hassenfuss, and distinguished members of the Criminal Justice and Public Safety Committee. My name is Jan Collins. I'm Assistant Director of Maine Prisoner Advocacy Coalition, MPAC, an organization committed to ethical, positive, and humane changes in Maine's prison system. I'm speaking in support of LD 1962. MPAC often receives requests for assistance from people in prisons across the state. The requests are made after individuals have exhausted all avenues allowed them within their place of confinement according to policy. Most of the requests revolve around lack of medical care. Just a few examples. Teeth that have become infected while medical care has been denied, the pain becoming so intense that individuals have resorted to pulling their own teeth. An individual whose bicep tendon had detached and was bunched in the crook of his arm. He waited over 6 months for an MRI recommended by medical staff. A man who had lost the use of his legs and has been wheelchair bound for years had his footrest taken by medical, ostensibly for repairs. Months later, it had not been returned. With no footrest, his dragging foot was caught under his wheelchair, flipping him forward, sustaining injuries to his face and hands. He waited several more months before he was able to get his footrest back. Other non-medical examples, some of which have been mentioned by others, an HVAC system that does not provide adequate heat on the coldest days of the year and does not provide cooling in some buildings in the summer. A mailroom that holds mail for weeks. A grievance system that dismisses grievances not based on the validity of a grievance, but on whether or not the complainant stays within the lines.
Jan, can I ask you to wrap it up, please?
Thanks. These people are looking for help. They've tried to work within the system and have been unsuccessful. In desperation, they turn to us. You have to be desperate to turn to an organization that has no power. We listen, we bring their request to the DOC's attention, but that is the extent of what we can do. Sometimes it helps, often it does not. People who find themselves in DOC custody often feel that they have been disappeared. The walls are high, we cannot see through them, the public cannot enter, media have difficulty getting access to information, most people have no idea what goes on inside. The question is not whether an independent ombuds office is needed for the Department of Corrections. The testimony you have heard here today provides overwhelming evidence of the need. The question is whether or not people who are incarcerated deserve to be treated with humanity. I hope your answer will be yes. Please give your full support to LD 1926. Thank you.
Thank you. Are there any questions? Seeing none, thank you.
Thank you.
I hope you'll come to the work session.
Yes.
Is there anybody else that would like to speak in favor of this legislation? Deborah? Is your microphone on?
Yes, can you hear me?
Okay. We're trying to time it for 3 minutes. Okay.
I've timed myself, so I should be okay.
Good, thank you.
Sure. So hello, Honorable Senator Bibi Center, Representative Hassenfuss, and esteemed members of the Criminal Justice and Public Safety Committee. My name is Deborah Sescher. I live in Brunswick, and I am writing with urgent concern and full support for LD 1962. As I've come to learn the hard way, the Maine Department of Corrections is allowed to operate with very little transparency and no meaningful oversight from the public. I'm asking for your support for this bill, yes, for the residents in MDOC, but also for the free people in the ecosystem who are victimized by the lack of oversight, namely MDOC staff and family and friends of loved ones of residents. I believe MDOC can be a system that operates well and takes decent care of people who live and work within and around that system, but it is through painful personal experience that I know it currently is not. My hope would be for an independent ombudsman office to finally bring some accountability to bear. For residents, I have seen the sometimes arbitrary nature of the MDOC disciplinary process and application, and have learned how often these processes are unconstitutional in practice. Similarly with the grievance process. In current practice, the grievance process is likely to invite retaliation without actually solving the problem being grieved. An ombudsman could lower the risk of retaliation and increase the likelihood of problems being solved. I was shocked to hear how badly prison staff need this office to be created. There have been many reports of staff hazing, sexual harassment, and other forms of horizontal and vertical violence. Lawsuits have been filed both by security and nursing staff over the past several years. If an independent ombudsman office had been in place, maybe these staff members would have been heard when they reported the harmful behaviors that they experienced, and there could have been correction for them to feel safe enough to stay in their jobs. And finally, this position is needed for the friends, family, and loved ones with someone under MDOC care. The most perfect example of why this fact is necessary is that I am scared to share any personal stories that I have been through with you today. No one is looking, no one is listening, and it's free members of the community like me who pay the price and live in fear when MDOC is allowed to operate in the shadows. In short, an independent ombudsman office has the potential to help residents, staff, and our community, ultimately leading to prisons that are safer to work in and more conducive to positive change for those incarcerated there. So please, 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 please vote ought to pass on LD 1962. Thank you.
Thank you very much. Are there any questions? Seeing none, thank you. I hope you'll come to the work session.
Thank you.
Is Brian Weidenhouse or Simone May?
He's not here, but Brian.
Brian is?
Yes, there he is. Turn on this camera.
Brian, can you turn your camera on? Okay.
Yes, thank you. Good evening or good afternoon. I started with good afternoon, but we're now approaching good evening.
Yes, we are.
Well, Senator Beebe Center, Representative Austin Fuss, and honorable members of this committee, it is an honor to speak before you today in support of LD 1962 to establish a corrections ombudsman. My name is Brian Whitenhouse, and I'm a state legislative affairs manager at FAM, a national nonprofit, nonpartisan justice reform organization. While I do not live in the great state of Maine, I'm privileged to represent hundreds of families in our network who have incarcerated loved ones. FAM advocates for policies that are individualized and fair, protect public safety, and preserve families. Our organization has played a leading role in the development and implementation of prison oversight and ombuds offices across the country, namely the Federal Prison Oversight Act. Just this past year, I worked closely with a coalition of stakeholders in Arizona comprised of community members, impacted families, state organizations, correctional staff organizations, and government officials to pass legislation creating a prison ombuds office just like what LD 1962 would do. My colleagues at FAM have also played similar roles in the past 2 years to create such offices or systems in Maryland and Virginia as well. Today, I hope to share some of my experiences and knowledge gained from supporting legislation such as LD 1962 in these other states and jurisdictions. In times past, the concept of oversight has been viewed as either redundant or unnecessary, or sometimes as adversarial to correctional agencies. I can tell you that that is not what the case today. It's rapidly changing. By working together with all stakeholders, oversight or an ombuds office can be collaborative and in supportive role. FAM has worked in hand with One Voice United, a correctional advocacy organization, on such legislation. The concept of a safe and efficient prison setting equally applies to staff as it does to incarcerated population. The ombuds can also alleviate the burden on prison staff by fielding the phone calls and letters from many family members that they are now receiving, freeing up many manpower hours. However, traditionally, as you've heard from other testimony, many family members are afraid to raise concerns sometimes. This leads to unreported or unrecognized issues which slowly grow over time and leave family members feeling afraid and hopeless. Additionally, legislators in other jurisdictions have been shocked and blindsided by such things as the cost of crumbling prisons and that have been condemned and either need expensive repair or replacement.
Can I ask you to please wrap it up?
Yes, I'm.
The 3 minutes is up. Thank you.
There are also lawsuits over subpar conditions in medical care, rampant sexual abuse, violence, and drugs. Please know that I'm in no way inferring that these are problems in Maine. I'm merely sharing what has happened in other jurisdictions. The role of an ombuds is a valuable tool to keep legislatures informed. Just like a safety inspector, the ombuds can help the legislature take preventative measures to identify problems rather than react to them. And I'll cut it short and I'll just ask that this committee please vote to pass. Thank you.
Thank you very much. Are there any questions? Seeing none, I hope you'll come to the work session.
Thank you.
Is there anybody else that would like to speak in favor of this? Is there anybody else online?
Not that's one sentence, they just raised their hand. They're not registered or not.
Okay.
With Nicole. And she needs to put on her in her mind.
Hello? Is your mic on?
Yeah.
I believe so. Can you hear me?
Are you speaking in favor of this bill?
I am, yes. I'm speaking in support of LD 1962.
We are doing 3-minute testimonies at this point.
Okay.
You could keep it to 3 minutes. Thank you.
I'll do my best. Thank you. So I am reading on behalf of Earl Baylor. To the esteemed members of the Criminal Justice and Public Safety Committee, my name is Earl Buddy Baylor. I am incarcerated at the Main State Prison, and I'm here to tell you from the inside, the lack of accountability is impossible to ignore. Inside prison, everything is done in bulk. Mass lockdowns, mass punishment, mass decisions about human beings with no explanation. Entire units can be locked down for days or weeks. Programs stop and mental health declines. People are left to sit, wait, and deteriorate. And there is no independent place to say, hey, this isn't right. Who is watching the watchers? Food portions have gotten smaller. Medical requests are delayed or ignored. Grievances are reviewed by the same people complaining about the things. That is not an oversight. This is a system protecting itself. Right now, incarcerated people are expected to follow every rule or face consequences immediately, while the institution faces none. There's no neutral body watching patterns, asking hard questions, or holding anyone accountable. That imbalance creates harm, resentment, and unsafe conditions for everyone, prisoners and staff. An independent ombuds office would change that. It would give people inside and their families a safe place to report concerns without fear of retaliation. Retaliation is real. An ombudsman would look at systematic issues instead of dismissing everything as a one big complaint. This bill is not about being soft on crime. It's about transparency, dignity, and basic fairness. If incarcerated people are expected to take responsibility for their actions, the institutions overseeing them must be held to the same standard. I urge you to support LD 1962 and bring accountability where it has been missing for far too long. Thank you. Sincerely, Earl Buddy Baylor.
Thank you. Are there any questions? Seeing none, thank you very much.
Thank you.
Is there anybody else online?
They're not, there was somebody named Ariel Ritchie. But I don't. No, if they want to testify.
Okay.
Yes.
Okay.
I would say if I'm not sending it just.
Okay.
Yeah.
Oh, wait, he or she just raised. Scared.
She was here.
Yeah.
Hi, I'm testifying neither for nor against, so I don't know if that's the appropriate time as yet.
Well, it's coming close.
She's there. There we go.
There's no one against it. Is there anybody here who's not in favor of this legislation? You aren't, okay.
And then.
Could you hold on for just a couple minutes and we'll, what we're going to do is have someone who's speaking against it and then we'll have you speak neither for nor against. Would that be all right? Thank you. Would you come up? Thank you.
Good evening.
Good evening.
Senator Beebe Center, Representative Hafsafas, and distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety. I'm Anthony Cantillo. I serve as a Deputy Commissioner for the Maine Department of Corrections, providing testimony in opposition of LD 1962, an act to establish a corrections ombudsman. As written, the bill would establish an office of the Corrections Ombudsman that would oversee prison operations, but not the county jails. Without any justification for focusing solely on one slice of Maine's incarcerated population, there's no need for an entirely new office of state government to cover the approximately 2,060 residents in the department's custody, where there are already many channels for our residents to pursue complaints and make requests. These processes include the DOC's grievance procedures, available to all residents and publicly online, which was developed under the Administrative Procedures Act, meaning it was formulated with public comment, and after a public hearing cannot be changed by DOC without going through that process again. Under the grievance procedure, a resident may challenge departmental actions that affect the resident, and those decisions may be reversed or modified and is appealable through the facility level up to the commissioner's office. Discipline and classification decisions such as housing placement and custody levels have their own separate process outside the grievance procedure. Residents may appeal disciplinary decisions through the facility level to the deputy commissioner level, and residents may appeal classification decisions to the director of classification. In addition to the grievance procedure and discipline classification process, residents may file a complaint with Maine Human Rights Commission by mail or phone. That commission now investigates resident allegations of all types of discrimination, when under prior law, the commission could only investigate complaints of disability discrimination. Residents may make a complaint against a DOC staff member by reporting it to other DOC members, who in turn refer the matter to the Office of Professional Review, which completes a preliminary investigation of complaints where a policy or statutory violation is alleged. If the allegation is found to be a credible violation, the investigation continues and discipline may be imposed on the employee. Residents can also pursue complaints or advocate for themselves through the resident advisory councils, which meet regularly with facility administration. If they are dissatisfied with grievance process, there's also court intervention and state through civil actions through petitions under Maine Civil Procedure Rule 80C. There's also complaints for sexual harassment and sexual assault through the Prison Rape Elimination Act. There's also interfaith councils for residents to bring up their religious practice complaints or concerns. And anyone can file a complaint to the Maine Department of Corrections website. And being mindful of time and knowing that you have the testimony in front of you, I will outline that there are areas in here that also have concerns in the department regarding this proposal in this bill. And as outlined, department is being recognized as the progressive steps towards corrections. And many of the steps, to include the nomenclature as identifying people like prisoners or inmates as residents in our system, is something that we self-imposed and identified as being the right thing. So in summary, we strongly just urge this committee to vote not to pass an LD 1962. Happy to answer any questions and be welcome back to the work session.
Thank you very much. Are there any questions? Yes.
Thank you, Madam Chair. Mr. Cantillo, for the work session, based upon the context of the bill with a estimated 0.13 to 0.16% appropriation against the department's annual. Can you approximate that number for us for the work session?
I have it quickly for you, Representative. It's
Sure.
about 400,000.
400K? Thank you. No further, thank you.
Are there other? Yes. Senator Shearway.
Thank you, Madam Chair. Now, many times for a release and stuff, you have the parole board, right? The kind of a board that kind of reviews everything before they release them of any sort. Do you have any?
For parole?
Well, we'll just say, I knew a family who said that they had a relative that was in the prison, said they had health problems, whatever, and then they somehow had a review, and then they felt that he was fine to release, so they released him, but then he ended up killing 2 more people. So I'm worried about somebody that's an ombudsman that may not have the DOC skills to know what's, how it works, how it goes on, and then they try to influence trying to get them out or get certain things, and I'm just wondering how that would work.
Well, I think that each avenue of complaint, they may come through the ombudsman's office. I think your question, Senator, is pretty broad and, probably need some specifics to work through.
Right.
But I think you hit upon that, many of the aspects that the department does have is, intimate awareness of our operations and the individuals of our care. And we do take a look at those cases individually.
Thank you.
Are there any other questions? Representative Milliken?
Thank you, Madam Chair. Thank you, Deputy Commissioner Cantillo. It's nice to see you. I feel like you've been in here a lot this week. You really hit the ground running.
It's only 2 days, Representative.
I'll probably see you tomorrow
You
too, I
will.
think. I have a few questions. One is, I mean, you know that I go into Maine State Prison quite frequently, and I've been to all of the other facilities, and I've heard from many residents that the grievance process is not adequate. And I think that's putting it mildly. And I guess one of the complaints I've heard is that often when they're complaining about a specific officer, they're complaining to a loved one of that officer. And do you think that that's a fair, I don't know how to ask this as a question, I guess. Do you think that that system that is set up currently is adequate and addressing all the concerns of the residents in your care?
I'm not fully understanding your scenario of a complaint being brought up against an officer to a loved one.
You have many staff members who are friendly with each other, loved ones of each other, care for each other, family members even of each other. And so I've heard from a number of residents that they will complain about one officer to an uncle or a cousin or a good friend of the officer they're complaining about, and that sets up a conflict of interest where the conflict can't be taken care of, I guess, in a way that feels entirely, I don't know what the right word is for it, but doesn't necessarily alleviate the concern of the resident that's complaining.
All right, thank you for that clarification. I think that, again, these are procedures that are outlined through APA. And in your specific example is the first time I'm hearing something relative to that type of concern. So I think at the moment, though, in general, our processes are in work, but we have also shared that we are also a department working on progress and continuous improvement. So we're not shying away of identifying the need for continuous improvement in all categories. So I do welcome what your feedback was, and I absorb that.
Senator Curry?
Thank you. Thank you. I understand you're opposed to this legislation. If the committee does decide to move forward with it, is there a reason not to include the county jail system?
I'm not here to speak upon the county jail system. The only thing I will add is if there are complaints that get filtered through the Maine DOC website, which the process is related to the county jail, we do share that to jail administrators to make sure that it does get passed along, and we log that information as well.
Thank you.
Are there any other questions? I hope you'll come to the work session.
Thank you.
Thank you. Is there anybody else that would like to speak against this legislation? Is there now someone who would like to speak neither for nor against? Please.
Good evening, Senator Beebe Center, Representative Hassan-Foss, and members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Ariel Ritchie, and I'm the Executive Director of the Permanent Commission on the Status of Racial, Indigenous, and Tribal Populations. I'm here on the Commission's Policy Committee's behalf to testify neither for nor against LD 1962, but to provide information and context that is hopefully helpful to you. It's hard to say what the precise impact of a corrections ombudsman would be on marginalized populations because we currently lack the information to know whether Mainers of color in the corrections system face higher rates of unsafe conditions or ill treatment. I'll also just pause there to say that we did receive some anecdotal information from MPAC that there are significant racial disparities in solitary confinement rates. If that's something that the committee is interested in hearing more about, they could consider asking the Department of Corrections to bring information about that to the work session. We do know that Mainers of color are disproportionately incarcerated and that there are gaps in our knowledge about conditions that an impartial third party could help shed more light on. Maine ranks 44th out of 50 for racial disparities in state prisons, with Black Mainers incarcerated at 9 times the rate of white Mainers and Indigenous people incarcerated at 6 times that rate. Current racial disparities in incarceration rates are connected to individual and systemic biases across areas such as policing and conviction and sentencing rates. Maine experienced a 163% increase in incarceration rates between 1983 and 2015. However, we don't currently have transparency on the treatment of incarcerated people. A corrections ombudsman might be helpful in shedding light on conditions that incarcerated people and corrections employees don't currently have the resources to speak out about without fear or retaliation. For example, Maine State Prison residents went on hunger strike in March of 2024 to protest solitary confinement-like conditions, but the Department of Corrections disputed their claims. This speaks to the need for additional independent information. According to the National Conference of State Legislatures, at least 19 states currently have a prison oversight body that is independent from the correction agency that they oversee. Additionally, data on health conditions for both residents and staff of Department of Corrections facilities is lacking. UCLA law collects data from all states on reported deaths and has identified age, sex, and race as missing demographic information in public records when deaths occur in Maine state prisons. They also collected COVID-19 case, death, testing, and vaccination data made publicly available for residents, and staff gave Maine an F rating for our lack of reporting of that data. This indicates gaps either in our monitoring or reporting of health and safety conditions for both residents and staff that could improve with the presence of a corrections ombudsman. Thank you for your time and attention. If you'd like further information about racial disparities in Maine, our office has a number of reports on our website, including our State of Racial Disparities report, and I'll append a copy of the relevant section to the testimony that I'll submit online.
That would be excellent. That would be excellent. Thank
Absolutely.
you. I hope you'll come to the work session also.
Yes, and if just one final point, if I could just uplift, I noticed a testimony was submitted online from the Maine State Prison branch of the NAACP, which represents Black residents at the Maine State Prison. And that is online. And so just encourage committee members to take a look at that.
Thank you. Thank you very much. Are there any questions for Ms. Ritchie? Seeing none, thank you.
Thank you very much.
Is there anyone else online? Reese? Okay. So I believe that's the last testimony of, oh, I'm sorry.
No, one more bill. Sorry about that.
No, I know there's one more bill, but is there anybody else who would like to speak neither for nor against this bill? Okay. Good. So that's the end of this bill. Oh.
We're still on.
Representative Lee, are you ready to present your bill? Excellent. Okay. So our final bill, Representative Lee is going to present.
Shocking, right? Morning. Morning. Evening. Well, you know, come on.
Thank you.
See you tomorrow. Hello.
Hi, sorry it took so long.
You know, I was just next door and we were working too, so.
Okay.
Yeah. Senator BB Center, Representative Hassenfuss, and distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety. I'm Adam Lee. I represent House District 89, which is downtown and New Auburn. I'm here to introduce LD 1671, an act to establish disclosure requirements regarding law enforcement credibility information. This bill deals with Brady and Giglio disclosures required by the Constitution. In essence, the law requires disclosure of exculpatory and impeachment evidence when such evidence is material to guilt or punishment. Frequently, the exculpatory and impeachment evidence deals with previous misconduct by law enforcement officers involved in the case. Presently, there is no statutory process to regulate how the disclosure between the law enforcement agency and the prosecutor should happen. This means there are sometimes disagreements between law enforcement and the prosecutor's office as to what information is to be disclosed and what methods exist for law enforcement to challenge the potential disclosures. This bill attempts to fill that void. I've brought this bill forward on behalf of the Maine Chiefs of Police. They are working with the Maine Prosecutors Association on a mutually agreeable statutory resolution to this issue. This bill was thankfully carried over by the committee to accommodate that work. It is my understanding that that work is ongoing, and we're hopeful an agreeable solution is in the future. Thank you for your time. There are folks behind me who are willing to testify as to this and can inform you as to the status of those discussions. And I'm happy to answer any questions if I can.
Are there any questions for Representative Lee? Yes.
Thank you, Madam Chair.
Representative
Thank you,
Milliken.
Representative Lee. Was there any attempt to have criminal defense attorneys represented in the conversation to determine what should be disclosed?
So the question is not what can be disclosed, it's whether that disclosure, what discussion happens between the police, the law enforcement side, and the prosecutors. The defense attorneys can make their own arguments as to what they believe should be disclosed, but this deals with the place where there's disagreements between law enforcement and the prosecutors specifically.
Are there other questions for Representative Lee? Seeing none, thank you very much. Is there anybody who would like to speak in favor of this legislation?
Good evening.
Good evening.
Senator BB Center, Representative Hassenfuss, and honorable members of the Criminal Justice and Public Safety Committee. My name is Jason Mullen. I'm the Chief of Police for the Auburn Police Department and the immediate past president of the Maine Chiefs of Police Association. I am pleased to present testimony on behalf of the association in support of LD 1671. The Maine Chiefs of Police Association's mission is straightforward: to strengthen the working relationships among police leaders, to promote professionalism and consistent standards across the state, and to support the men and women who serve our communities every day. At the heart of that mission is a shared commitment to protecting life and property and upholding the values of our profession. This bill was introduced at the request of the Maine Chiefs of Police Association because Maine lacks a clear and consistent and fair process for handling law enforcement officer credibility information, often referred to as Giglio material. While agencies and prosecutors are making good faith efforts, the absence of a minimum uniform standard has resulted in some inconsistent practices across prosecutorial districts, unclear expectations, and in some cases, career altering consequences for officers without adequate due process. Over the past year, the Maine Chiefs and the Maine Prosecutors Association have been working collaboratively to build a model policy and a memorandum of understanding. Those conversations have been productive and collaborative, and LD 1671 provides the statutory structure needed to support that work and ensure that its consistent application across the state. LD 1671 accomplishes three essential objectives. First, it clearly defines what credibility information is. These definitions matter. They ensure that agencies know precisely what must be reported, such as sustained findings of untruthfulness, evidence tampering, constitutional violations, or patterns of bias, and they prevent inconsistent interpretations from county to county. Second, the bill creates a fair and transparent process for officers. When a prosecutor is considering disclosing credibility information to a defendant, the officer must be notified, given an opportunity to provide input, and allowed to request an in-camera review by the Superior Court. This ensures meaningful due process while fully preserving a prosecutor's constitutional obligations to disclose exculpatory information. Third, LD 1671 requires both law enforcement agencies and prosecutors to adopt written policies by a date certain. Importantly, it requires prosecutors to establish a process for removing credibility information that is later determined to be inaccurate or false. This is critical. Without such a mechanism, an officer's career can be permanently damaged by information that should have never been retained. Finally, the bill gives officers a clear path to petition the Superior Court if a prosecutor's office continues to maintain information that is demonstratively false. That safeguard is essential for the fairness, accountability, and confidence in the system. LD 1671 is balanced, collaborative, and necessary. It strengthens the justice system, protects defendants' rights, supports prosecutory responsibilities, and ensures officers are treated with fairly and with due process. On behalf of the Maine Chiefs of Police Association, I respectfully urge the committee to support LD 1671. Thank you for your time, and I'd be happy to answer any questions.
Thank you very much. Are there any questions for the chief? Seeing none?
Thank you.
Thank you very much. Is there anybody who would like to speak in favor of this legislation? Is there anybody that would like to speak? Is there anybody online?
No.
Is there anybody who would like to speak against this legislation?
Good evening, Senator Beebe Center, Representative Hassenfuss, and distinguished members of the committee. My name is Julie Ann Smith, and I am here this evening on behalf of the Maine Law Enforcement Coalition to testify in opposition to LD 1671. The coalition represents all of the actual law enforcement officers. We do not represent any management, and we have a very different perspective on what this bill does. First, the bill defines credibility information far too broadly and includes unproven, unreliable, and prejudicial material. While the bill includes sustained findings, it also sweeps into categories such as publicly aired allegations, alleged criminal conduct without conviction, and vague facts reflecting impaired ability to perceive or recall the truth. These provisions would require disclosure of mere accusations, media claims, or unsubstantiated assertions that have never been tested through investigation, discipline, or judicial review. This undermines the fundamental principle that allegations are not proof and risks irreparable harm to an officer's reputation and career. Second, LD 1671 erodes basic due process protections for law enforcement officers. Although the bill provides limited notice and an opportunity to respond, it nonetheless mandates the creation and maintenance of credibility records before meaningful adjudication occurs. Once disclosed, the damage cannot be undone, even if the information is later found to be inaccurate or false. The after-the-fact petition process in Superior Court places an unreasonable burden on individual officers to correct governmental records that never should have included unreliable material in the first place. Third, the bill will negatively impact criminal prosecutions and public safety. By encouraging the disclosure of marginal or speculative information, LD 1671 risks flooding prosecutors with material that is not constitutionally required and not relevant to truth finding. This will complicate prosecutions, invite unnecessary litigation, and provide defense counsel with impeachment material untethered from actual misconduct. The result may be fewer successful prosecutions, delayed proceedings, and reduced public confidence in the justice system. Fourth, the bill creates significant administrative and legal burdens without clear standards. The bill requires law enforcement agencies and prosecutors to track, maintain, share, and potentially remove credibility information across jurisdictions, yet it provides little guidance on evidentiary thresholds, retention standards, or consistency. This invites uneven application across counties and agencies and exposes municipalities in the state to increased litigation risk. Finally, LD 1671 risks chilling proactive and effective policing. Officers who know that unproven accusations or subjective claims may follow them indefinitely and be disclosed in criminal cases may be less willing to engage in proactive enforcement or difficult decision-making. This chilling effect ultimately harms the communities law enforcement is sworn to protect. The Maine Law Enforcement Coalition believes that transparency and accountability can and must coexist with fairness, due process, and effective law management. Maine already has robust constitutional, statutory, and ethical frameworks governing disclosure. 1671 is not a clarification of those duties. It is a significant expansion that will create confusion, inequity, and harm without improving justice outcomes. This proposed law sends a message to our law enforcement community that they should worry about liability and self-protection first, and that hesitation can cost lives. The coalition strongly supports constitutional policing, ethical law enforcement, and prosecutors' obligation to disclose material exculpatory and impeachment evidence as required by Brady, Giglio, and Rule 16 of the Maine Rules of Unified Criminal Procedure. Those obligations already exist in Maine law and practice. Unfortunately, LD 1671 goes far beyond those established requirements and would create serious unintended consequences for due process, officer safety, effective prosecution, and the administration of justice. For these reasons, the Maine Law Enforcement Coalition respectfully urges the committee to vote ought not to pass on LD 1671. I thank you for the opportunity to testify and for staying so late this evening, and I would be happy to answer any questions.
Thank you very much. Are there any questions? Yes.
Thank you, Madam Chair. What we have here is two really divergent opinions. And is there any hope for a compromise, or could there be a back and forth and come up with something that everybody would be okay with, or is that hopeless?
I wish we had been involved in the process from the outset so I could better answer that question. That was not something that the coalition had discussed at all. They simply read the bill and were very opposed to it as written.
So before the work session, maybe there could be an interaction to see if there was any hope?
We can certainly
Before we
request
vote
that.
either yes or no?
I will certainly request that from the coalition and see what sort of meetings we can set up and come back to you with a response at least.
Thank you.
Of course.
Representative Milliken.
Thank you, Madam Chair. Could you talk about what the current process is for disclosing a Giglio violation?
I personally cannot. I'm a lobbyist, not a law enforcement professional or an attorney. So the details of that I think are pretty extensive. I would be happy to have something written up for the work session by someone who knows a lot more than I do, but I would not want to on mic at this moment answer that question.
There are other questions. Yes, Senator Searwood.
So I'm understanding that, the Giglio Act was basically for like under oath, and you lied under oath and that sort of thing. But I saw it kind of abused in my department at one time, and caused somebody to say something, but it was vague what they said, and then somebody read into it and made it sound like a lie. And so yeah, I can see where this might be a problem, and it doesn't really, does it do it? And you mentioned something about it deals with mostly the people under the administration, but not the administration. Is that, how do you feel about that part?
Well, I think the way that it's written, it puts it's uncomfortable. I think it puts everyone in a very uncomfortable position where you have the requirement of management to make disclosures to the prosecutor's office. After the fact, you're then telling the officer that this disclosure was made. They have an opportunity to respond. It's a very short period of time. But I think it's, without, I think it's uncomfortable the way that it's written.
Yeah. Thank you.
Are there any other questions? Seeing none, thank you very much.
Thank you.
Is there anybody else that would like to speak against this legislation? Is there anyone that would like to speak neither for nor against this legislation? There's no one online, right?
Right.
Okay. That's it.
What?
I heard it. I was going to second thing on it. Guys have a competition. We do. Whoever makes the motion has to find out. No. I do have a proposal.
Is it that
That
back
if-
tire by itself?
That if you have two sentences before your question, you then have to buy. So that any questions during a public hearing. Two sentences to clarify, the third must end with a question mark. You got two periods.
I'm thinking you proposed donut.
Yeah.
Yeah. Like.
Want to get ready.
Yeah.
Just wait for the opportunity.